Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello. Good afternoon. Today is Tuesday, February 19th, 2026, and we are here today to go back to Athens, Georgia for the sentencing hearing in the Edrick Faust case. So many of you watched the trial with me, and I'm so happy that you did because, in my opinion, this was like a real life To Kill a Mockingbird. And many of you saw that a give, send, go was started yesterday for appellate costs for Edrick Faust's appeal, which is obviously going to be forthcoming, but appeals take years. I've pinned the Give, Send, Go fund in the chat for those of you who feel like you would like to donate, because I know so many of you felt so helpless watching this verdict and you just felt like you needed to do something, but you didn't know what to do. And so there's an option for you. Today, I have a special guest with me that who you may recognize from her frequent appearances on Court TV, and I think also Law and Crime and many news stations. Her name is Marie Pereira. She's a Haitian American immigrant, a former prosecutor, a seasoned criminal defense attorney, and a registered nurse. As a nationally televised legal analyst, she brings legal insights to a broad audience while passionately advocating for immigrant communities through the Haiti Immigration Project, which is a nonprofit organization that she founded. She's also a dedicated philanthropist and an advocate for victims of domestic violence, providing a beacon of support and empowerment for those in need. Please welcome my new friend, Marie Pereira.
Hello, hello. The check is in the mail, okay?
How are you?
I'm great, thank you. How are you?
I'm good. I have to tell you that I watch Court TV and I watch Law and Crime, and every time you come on, I stop and listen, because the thing I love about you, which I also find in me, is that you're not afraid to say what you feel. And you're not a fence sitter. You get on there and you tell them how you feel. And I played yesterday for the audience your clip from Court TV from the other night when you went on with Ted talking about your thoughts about the Edrick Faust case. And I'm going to just put Law and Crime up. Well, I have them in the background, so when it starts, we'll watch the sentencing together. But your initial thoughts on what, I know you didn't have the chance to watch the entire trial, because many of us don't unless we do it live. So initial thoughts, feelings, concerns.
First, we want to respect the victim and say to her family, we're sorry about what happened. We're sorry that you had to wait so long for justice. But with all due respect, I don't think justice was served 100% in this situation, because after hearing all of the testimony, all of the witnesses, if I were the 13th juror, I would still be confused and I would have found that there was reasonable doubt. I don't think that the prosecution met that burden. Not to say that Edrick Faust is an innocent man, but I'm going according to the black letter law and the black letter burden. I don't feel the state met that burden because I'm still confused.
Right. I feel like the prosecution spent most of the 8 days of testimony trying to defend Chris Melton, more so than even, I don't even know, there were days where Edrick Faust's name wasn't even mentioned in the trial.
And I understand why they had to focus on that. When I say they, I mean the prosecutors, because low key, the defense named Chris Melton as the third party culprit. So they had to bring him on to clear his name, to clear the air, so that they can continue to accuse the defendant. But in bringing him on, his demeanor on the stand seemed not so genuine. And all the facts that came out from 21 years ago, the investigation almost was telling him, what I saw one of the detectives, a female detective, I don't remember her name, but she was basically telling him, hey, dude, I'm paraphrasing, we found some of your DNA, between her buttocks and her vagina. And if you say you haven't seen her in 10 days before the crime, that doesn't make sense because the DNA in the buttocks wouldn't last that long. Maybe it slid down from her vagina to her butt. Think hard, and tell us, was it 3 days? In quotes, air quotes.
Right.
All right. You don't investigate a case with a person of interest, her boyfriend, and then you're basically telling him what to say to get him off the person of interest list. Make it make sense, sis. That part was really weird.
Yeah, it was, we need to explain away your DNA. And that was when they interviewed him in 2024. So the murder was in 2001. 25 years later, the state of Georgia enacts this Coleman-Baker Act, named in part for the victim here, Tara Baker. And the Coleman-Baker Act gave $5 million to solve cold cases. But one of the requirements of getting your case opened up again was that there had to be no viable suspects. So in my opinion, the cold case investigators, her name was Liz, and Chris Melton called her Liz, and Jeremy, he was on first name basis with them. They needed to justify this act. And in doing that, they needed to say that Chris Melton wasn't a suspect so that they could find someone else to maybe pin it on.
But he was a suspect. And when you hear the court.
Oh, Chris Melton, you mean?
Yeah. Right.
Yeah.
Chris Melton was a suspect, and the investigators basically told him what to do to get cleared. All right. But on cross, Ahmad Cruz really brought out the incompetence, intentional or not, of the investigation, because he said, okay, Chris Melton told you that he was at work. He didn't remember the address of his job. Did you go and look at cameras to even see if a brother was at work? Right. Did you investigate his alibi at all? And alibi is important here because he's saying he was nowhere in sight. He was almost like 60 miles away. That made no sense whatsoever. When you're investigating a case, you have to be neutral. You have to be open. There needs to be no confirmation bias. And it seems to me through cross-examination, Ahmad Cruz brought out confirmation bias, incomplete investigation, whether intentional or not. And that to me was another block of reasonable doubt.
Right. I mean, I think that, and also it's important to point out, in the 25 years preceding this reopening of this cold case, that there were 2 other white men that were considered suspects. One was a lawyer at the firm that she worked with. And the only thing that was missing from her apartment was her laptop, which is very interesting. Her diamond earrings were still in her ears. Nothing was stolen. There was tons of jewelry in the house. Her roommates were gone. So there was a lawyer from the firm that she worked at. And there was another white kid who was a law student with her that was in her study group. And so there were never any black suspects. There was, it was There was none of his DNA was found in the house, Edrick Faust. The only stuff found in the house were Caucasian hairs. Chris Melton's hair was found on the power cord that was used to strangle her. And they brought on 2 witnesses who said that they saw a black man walking that morning with an orange shirt on. And so it was suspicious.
You know what? Not even all the witnesses agreed. Some said, I don't remember. Some said it was a shirt. Some said it was a hoodie. So even the eyewitness statements, the witnesses came out of their mouth to say, hey, that was a long time ago, you know? And they tried to say that he lived like 585 feet away from where the crime scene was. But the truth is, at that time, he wasn't living there.
Right.
Right.
It was his stepmother's house. That was like his, like his mailing address, like his permanent address.
Exactly. So that part didn't make any sense either. And I saw a testimony from a fire chief who said there were no signs of forced entry.
Right.
And they impeached him with his own report.
Mm-hmm.
And then he said, well, I remember there could have been a screen that was put aside. What was there forced entry? Yes or no? At the end of the day, you said there was none. It was deadbolted. And the person who started the fire took off the knobs on the stove, went and got a cloth, put the cloth on fire, and it went back to put the burning cloth, I guess, near her body. The way she died, though, was just so heartbreaking. I could imagine how hard it was for her family to have to relive that.
Right. And it seemed like such a personal crime. He actually, whoever this was, took a chenille blanket and burned it on the stove and then threw it on her body. We don't even really have a solid time of death. There was it left more questions than it answered, this trial. And it took at least 10 years, I think, for the parents to even be able to get a death certificate in this case, because their excuse was that it contained information that only the killer would know. You know, she was beaten, she was strangled with that power cord, she was stabbed with that knife, and then the house was set on fire. And like you said, deadbolted from the inside. Somebody needed a key to be able to do that. I felt like we were watching a real life, real time To Kill a Mockingbird. And in 2020,
she was brutally raped, sodomized, orally, anally, just absolutely horrible.
A brutal crime.
Anybody can do that to another human being. I don't know that they solved this crime, and I respect the decision of the jurors, but putting myself as an analyst and the 13th juror, I will stand by my opinion and my analysis that the state did not prove guilt beyond a reasonable doubt based on all of the inconsistencies from the witnesses' mouths, from the DNA. And this was a case that absolutely almost 1000% relied on DNA. If the DNA is fucked up, can I say that?
Yeah, sure.
Okay. If the DNA is fucked up, there's a problem here. Yeah. I read that one witness was testifying to hair being in an envelope, right? Mm-hmm. And giving all of this testimony, and then just, to be meticulous, as Ahmaud Cruz was, right? He said, can you open it? The envelope. And when he opened it, there wasn't shit in there.
No, it was empty.
Fucking empty. Okay?
Empty.
To me, that shows such issues with chain of custody, with proper handling, with degradation of the DNA. There were little slides, and back then they didn't even have envelopes. They just took the slide, put it together, and taped it. What the fuck is off? I mean, we're talking about the life of a person here, and we're talking about justice for a poor girl who just was minding her business and her life was taken like that. So to me, the fact that he was convicted off that bullshit evidence they had really does a disservice to the victim, because at the end of the day, in my mind, if you didn't prove your case beyond a reasonable doubt, there may be a murderer, a killer, someone who did that still running the streets.
Yeah, I think there is. I mean, they had mislabeled those oral swabs, right? There were 2
Unbelievable.
oral swabs and 1 rectal swab and 1 vaginal smear. And what they did with those oral swabs was they sent them to California to a company called Pure Gold, okay, which it's pure gold for them because you know and I know these independent DNA companies, their bread and butter is law enforcement agencies, right? And their contracts with law enforcement agencies, that's where they make their money. And she did some Lugol's iodine test that I think has never been allowed in a court before, to say that there was a presumptive test for maybe some vaginal epithelial cells. So maybe that was really a vaginal swab. Like this is not about maybe. This is a man who will be sentenced today to life without the possibility of parole under Georgia guidelines. And maybe is not good enough.
No, maybe it's not good enough. It's beyond a reasonable doubt the burden of the state. And I feel like with all of the issues concerning the DNA, which was the crux of their case, there's reasonable doubt there. I'm not saying that, Edrick Faust is innocent. There's a difference between the state meeting their burden in a criminal case that involves someone's freedom, a serious felony case like that, to say there's reasonable doubt here. I don't even understand how the jurors came up with that.
And we have to hold the state to their burden in every single case because every defendant deserves a fair trial. And it's better that one guilty man go free, than one innocent man incarcerated for life without ever the possibility of parole.
We want justice, not just convictions, and we want justice that stays within the boundaries of what our laws say. And it has to be beyond a reasonable doubt, not maybe, could have, should have, I don't know. That's not the burden here. And that's what bothers me the most, because I still feel like there's a possibility that another person who's actually responsible for this is still running wild out here.
Right. And we read some old articles from 2008, 2010. And in those articles, Tara's mom said, listen, we know who did this. We know who did this. And it was probably one of those 3 other white men. Never was a black man ever in the mix until this alleged hit on CODIS. So here's another question that I had for you. They find his DNA. Allegedly, they match it up with CODIS and they get a hit in 2024. But he's been in the system as a convicted felon since at least 2001. Why
wasn't it there then? Right?
Yeah.
Where was the DNA match then? So it took them all of these years for them to make a match when you're saying he was, maybe, I don't want to say a recidivist, but he was no new person to the criminal justice system. So they had his DNA. Why was there no match then?
Right. And they kept retesting. All right, here we go. This is Judge Lisa Lott. She's a lot. We're going to Athens. Here we go.
It's a good one.
She's the head judge. She tells everyone every time. She loves people to know that she's the head judge in Athens. And she really tried to muzzle the media in the courtroom too. She said, you're not allowed to talk about the jurors' facial expressions, whether or not they're taking notes. You're not allowed to say anything that would identify them. It was wild.
Well, we want to protect the jurors, though.
Well, we don't have to say what they look like, but whether or not they're taking notes or paying attention, I think that's fair reporting, right?
I think so, too. There she goes.
I wonder if her mom is going to give it a victim impact statement.
I feel terrible for the victim, the family, because at the end of the day, that none of this brings her back.
No.
She was She was 24 years old.
Yeah.
Going into her 2nd year of law school.
The night before her birthday, she was murdered, and somebody had to know that the roommates weren't going to be there. And you, with your work doing, helping victims of DV, when is the most dangerous time to leave your partner? I mean, when is the most dangerous time for the woman or the partner?
Yeah. And, it's really funny how he tried to make it seem like they had a wonderful relationship, when in fact there was contrary testimony from her friends. Right. One of her friends even said there was a vigil a couple of days after the horrible incident, and he was trying to push up on her. He says he was comforting her. The friend says he was trying to come on to me.
He didn't even go to the candlelight vigil. Instead, he went with one of her besties to a country music concert. And then a couple of days later, went out with another one of her besties to lunch with Ashley, the roommate, and her husband, her now husband, that they're still friends with Chris. And he was rubbing her back, because he needed to comfort everyone.
So that part. And to me, just the fact that they finished undergrad, they didn't finish undergrad. They were in undergrad together. And he was a pre-med student, right?
Mm-hmm.
And he flunked out of school. She went on, graduated, and went to Georgia to go to law school. And he followed her. It's giving stalker vibe to me. Maybe when she met him, he was all fly and, going to be a doctor. And then after he flunked out, she said, I didn't sign up for, not to say there's anything wrong with an assistant plumber, but I didn't sign up for a person who didn't even graduate from college.
Right.
That was motive. That
exactly.
She was like a budding star and he was just like a brump.
Yep. And she didn't, it seemed like they were in the midst of a breakup.
Exactly.
He was like, okay, and what if she had consensual relations with Edrick Faust and Melton found out or walked in or saw it happen or, and
but you know what, with that,
that,
let me play devil's advocate with that before Judge a lot starts. We don't know if there was ever any type of consensual situation because Faust's attorneys did not bring that up. So I feel like it's unfair to the victim to even bring it up, right? Because they didn't bring it up as part of their defense. They had the right to file that 412 motion and present their case in the absence of the jury before the judge.
Ladies and gentlemen, we are here for
Let's see, I got a booster because it's soft.
the sentencing portion regarding the state of Georgia versus Edrick Faust, SU 24 CR 0547. The jury having returned a verdict of guilty on all counts in the indictment. Ladies and gentlemen in the audience, I want to take care of a few preliminary matters before we get started. The first is that no one in the audience, with the exception of media who have been granted a Rule 22 permission, can have their cell phones out and can have their cell phones out. So the first thing I want everybody to make sure is that if you have a cell phone and you are not the media who has been granted access, to put your cell phone away, please. And also, while you're doing that, to make sure that it is in the off position. I would appreciate everybody's cooperation on that. If there is anybody, of course, and I've mentioned this before during the course of all of our proceedings, if anyone does violate that portion of this court's order, having their cell phone out and certainly even using it, you will be escorted from the courtroom by the deputy and not allowed to return. The second thing I want to remind everyone, as I reminded everyone the other day who was here, is that this is a court of law, and certainly the court expects everyone to act accordingly. There will be no disruptions whatsoever, no outbursts of any kind, no yelling, no screaming, and no disruptions like that. If that does happen, I will stop the proceedings. The sheriff's department will escort that person or persons out of the courtroom. Everybody certainly was in full compliance the other day when the verdict was read, when I gave this same instruction. And I certainly appreciate everyone's abiding by that order very much. And I'd ask you certainly to do the same today. Is the state ready to proceed?
State's ready, Judge.
All right, Mr. Cruz, is the defense ready?
I have no other choice, Your Honor.
All right, thank you, sir. Mr. Faust, I'm going to address you now, sir. I want to tell you that, as you know, you have been convicted of all 12 charges as listed in the indictment by the jury, returning the verdict. I want to tell you that you have the right to pursue an appeal. If you cannot afford an attorney, the court will appoint an attorney to represent you for an appeal. I want to make sure you understand that filing an appeal has time limitations. You have 30 days from the date of sentencing, which will be today, to file a notice of appeal. Filing a motion for new trial also falls under that category of 30 days after the conviction sentence is entered. You also have 4 years if you choose to file a habeas corpus petition. If you cannot afford an attorney to represent you, the court will appoint an attorney for you. I certainly know that you will speak with Mr. Cruz today and other days about your rights of appeal, but I wanted to make sure you understood them. Do you have any questions for the court about those things? Thank you, sir. All right, if the state is ready to proceed, you may do so, sir.
Thank you, Your Honor. Judge, what the state would intend to do as it relates to our presentation of evidence concerned with sentencing is to begin by discussing the ranges and the counts on which Mr. Faust is to be sentenced from the state's understanding. At that point, Your Honor, I would tender in certain certified convictions in aggravation of punishment. Mr. Cruz has been provided copies of those. We would then offer 4 victim impact statements, Judge, from Miss Virginia Baker, Mr. Adam Baker, Miss Meredith Schroeder, and Mr. Kevin Baker. And after the victim impact statements, the state would make its recommendation to the court. As it relates to count 1, malice murder, the sentence is mandated by law as of January 19th of 2001 would be a sentence of life imprisonment. Counts 2 through 5, the felony murder counts, as a matter of law, since Mr. Faust was found guilty of malice murder, would be vacated. Mr. Faust is thereafter still eligible to be sentenced for each of the felonies that underlied those felony murder counts. That would be the burglary, aggravated sodomy, 2 counts, and then the rape. As it relates to the sentencing range for burglary being count 6, that would be up to 20 years. Count 7, the aggravated sodomy as it existed on January 19th of 2001, the state's understanding of that is that that would be a serious violent felony subject to the provisions of 1710 6.1 at the time, which indicates that when an individual is convicted of a serious violent felony, if they are sentenced to anything other than a life sentence, they are not parole eligible for whatever that sentence is that is imposed by the court. And the range on aggravated sodomy at the time was 10 to 30 or life. As it relates to, and that would be the same for count 10, Your Honor. As it relates to count 8, the rape count, that would be 10 to 20 or life. As it relates to count 9, the aggravated assault, that would merge with count 1 for purposes of sentencing. We've already covered the range on count 10. Count 11 would be up to 20 years, and count 12, possession of a knife. I'm sorry, count 11 was the arson in the first degree. Count 12, the possession of knife during commission of a felony would be 5 years, Your Honor. And Judge, would the court like us to continuing numbering exhibits from the exhibit number in the trial, or to start with 1 for purposes of sentencing?
That's a great question. I think we should continue with the numbers that we've been going on. Do you have the last number that was entered?
I do not.
Okay. Okay. We can do that. Sure. I think that sounds fine. Ms. Satterfield really is in charge of all of those numbers. That's important for her. So we'll start again with 1. She thinks that would be best. So go ahead and label whatever document you have as State's Exhibit 1, and then follow with any other exhibits you have in numerical order.
Thank you, Your Honor.
All right.
And Your Honor, I've labeled for purposes of sentencing State's Exhibits 1 through 6. Exhibit 1 is a certified conviction from criminal action number 93 OR 36B, which was a sentence entered on an attempted robbery charge with a sentencing date, original sentencing date of June 7th of 1993. This document was for a first offender sentence. It was later adjudicated guilty. In State's Exhibit 2 is 96 OR 165J.
Yes.
I would object to the state attempting to use prior convictions and aggravation of sentencing If my recollection doesn't fail me, we didn't receive notice that the state intended to use Mr. Faust's prior record for sentencing either the last day of trial or the day before the last day of trial. The state provided us with documentation stating that they intended to use Mr. Faust's record in aggravation of sentencing. As the Honorable Court is aware, under OCGA section 17-16-4, section A5, the law states that the prosecuting attorney shall no later than 10 days prior to trial or at such time as the court orders, but in no event later than the beginning of the trial, provide the defendant with notice of any evidence in aggravation of punishment that the state intends to introduce in sentencing. And that is a shall statute. The state failed, unless they could show something, because from what they gave me 2 days ago, 2 days before the end of trial or the last day of trial, that was my first time seeing those documents. But the state hasn't met the notice requirement to introduce evidence in aggravation of sentencing under that statute, Your Honor. So I would ask that if the state wants the Honorable Court to proceed with sentencing, that's fine. But I would ask the Honorable Court not to consider the state's evidence in aggravation because they failed to follow the proper procedure for admission of same. Thank you, Your Honor.
Thank you, sir. Any response, Mr. Yellow-Chile?
Yes, Your Honor. I don't have both of the dates in front of me, but the state provided its first notice of intent to use any convictions contained in Mr. Faust's criminal record in aggravation of punishment as part of its discovery certificate that was filed on, I believe, April 2nd of 2025. Subsequent to that, we provided a more specific notice that listed 3 convictions coming out of Clarke County, and then we amended that notice with the second notice of intent to use prior convictions in aggravation for recidivism, which doesn't necessarily apply here for purposes of impeachment as well. But the original notice is from April 2nd of 2025.
Thank you. Yes, sir.
I would ask the Honorable Court not to take Mr. Yalamachile's word for it. If the Honorable Court could review the record to make sure that it's accurate. I disagree with that position, but I may be mistaken. I would just ask the Honorable Court to confirm.
Okay, thank you, Mr. Cruz. I actually have reviewed the record, and Mr. Yellow-Chile is correct. So I'm going to overrule your objection. I'm also holding in my hand the state's second notice of intent to use prior convictions in aggravation of sentencing, and that was filed on October the 2nd. So I have one of them actually in my hand, but I have reviewed the record, and Mr. Yellow-Chile is correct, sir.
Yes, ma'am.
All right, thank you. You may proceed.
And Judge, so State's Exhibit 1 was a conviction for attempted robbery, Your Honor, with the date that I noted. State's Exhibit 2 is a certified conviction regarding possession of a firearm by a convicted felon and other offenses from 96 OR 165J, again, out of the Superior Court of Oglethorpe County. Then we come to the 4 Clarke County convictions that the state intends to admit for aggravation. State's Exhibit 3 is SU 01CR0298. This was an aggravated assault committed on February 4th of 2001 involving cutting or another individual in the neck area, and the sentence date on that particular offense, I believe, was September 6th of 2001. Obviously, the offense date is within a couple of weeks of this murder. And then State's Exhibit 4 is SU 11CR0744. This is a certified conviction, again, for Mr. Faust for a felony. And it is a conviction for possession of cocaine as well as driving while license suspended and misdemeanor obstruction of a law enforcement officer. State's Exhibit 5 is another certified conviction. This is SU 13CR0203 out of the Superior Court of Clarke County. And this is a conviction for possession of cocaine with intent to distribute, as well as misdemeanor obstruction of a law enforcement officer. And Your Honor, the sentence date on this particular case is November 6th of 2013. And then State's Exhibit 6 is SU 14 CR 0774. And it's for a felony driving while license suspended, Your Honor. The conviction date of this case will be November 26th of 2014.
Yes, sir.
I just pulled up the notice that the Honorable Court mentioned from October. It only mentions 3 offenses. That's the aggravated assault. That's the VGCSA, 2 counts. I don't just wanted to let the Honorable Court
That
know.
was the only one I had in my hand, but I have reviewed the record.
I just want to make sure.
There's an amended notice as well, Mr. Cruz, but the one that I was referring to is the one I have in my hand.
Correct. The amended notice, I only received that 2 days before the end of trial, Your Honor. So we're asking that those convictions not be considered. The 3 that's in the notice filed in October, obviously that meets the statutory timelines. The ones that they gave me 2 days before the verdict came down, that does not meet the statutory timeline, Your Honor. So I'd ask the Honorable Court to reconsider its ruling.
Thank you, sir. Any response to the objection again, Mr. Yelmichilli?
Well, again, Your Honor, if we go back to, and I believe it's April 2nd of 2025, but the court has the record in front of it. As part of the state's discovery certificate, we provided notice of both impeachment, aggravation, and I believe also recidivism for any convictions that were contained in Mr. Faust's criminal history. There's no, to my knowledge, no subsequent requirement of the state to make a more specific notice, but we chose to do so.
Yes, sir.
The law requires a specific notice. So there is a requirement for that, Your Honor.
I'm not sure that's correct, Mr. Cruz, and I'm going to overrule your objection and allow the state to continue.
All right. And so, Your Honor, if I could approach, I have states
You may.
1 through 6.
Thank you. You may proceed.
Thank you, Your Honor. At this time, we'd ask the court to hear victim impact statements, beginning first with Miss Virginia Baker.
Good afternoon, Your Honor.
Good afternoon.
I am Tara's mother. I will always be Tara's mother. And I'm afraid my emotions are about worn out after these 25 years of pain. And so if it is okay, I have asked my son-in-law to read my statement for me, if that would be all right.
Yes, ma'am. That is certainly all right. Go ahead.
Thank you, Your Honor, members of the court. There are no words to fully express the horror of what this monster did to my daughter, Tara. For weeks, I have sat in this courtroom, forced to look at evil, to hear details I never wanted to know. I have endured it only for her sake. January 19, 2001 was the collision of pure good and incomprehensible evil. Over these 25 years, the truth has emerged slowly, each new piece more terrible than the last. The question that never leaves me is why? I have asked God this question thousands of times. I still have no complete answer, and the pain remains. As a mother, I cannot bear the image of Tara dying alone, frightened, calling for help that never came. Night after night, I dream of carrying her burned and broken body, walking endless roads, trying desperately to find someone who could help, someone who could bring her back. I have begged God to trade my life for hers. She is gone. The emptiness she left is vast and unending. Tara was intelligent, kind, dutiful, and loving. She worked hard toward her dream of becoming a lawyer so she could help others. Yet she never lost her generosity or her caring nature. Her life was full of promise and light. The person who took her lived in complete opposition to everything she stood for. His actions were selfish, depraved, without compassion or regard for the lives he destroyed. He did not only end her life and her dreams, he tried to erase her completely by setting the fire. Our family had never known violent crime before that day. Her absence still wounds her siblings, her friends, and all who loved her. The pain is constant, even in moments that should be joyful. I will never forget sitting beside her closed casket, praying it was all a mistake, that we would open it and find it empty. Though I begged to open the casket to see my sweet girl one last time, my husband and the funeral director protected me from seeing the devastation that Edrick Faust had caused. The impossible hope that somehow she was not in that casket was the last thread I clung to before accepting she was truly gone. After 25 years of living in the shadow of this loss, praying, waiting, and enduring, the final chapter has been written today. As the district attorney reminded us, it was the jury's solemn duty to hold the pen and write the correct ending to this tragic story. They have done so, bringing accountability at last and allowing light to pierce the darkness that has shadowed our family for so long. Tara's beautiful soul is now safe with our Lord. Her short life was filled with love, and that love endures in every heart she touched. I thank God for the grace that has carried me this far. I thank him for my remaining children, Tara's siblings, and I thank him for my grandchildren. We all thank him for the legacy of light that Tara left behind. Tara was and always will be deeply loved. Such a beautiful life, so full of promise. Thank you for your time, Your Honor.
Thank you. Mr. Cruz, anything from the defense with regard to this victim witness?
No, ma'am.
All right. Mr. Yalamanchili, you may call your next witness.
Your Honor, the state would call Adam Baker.
On January 19th, 2001, my beloved sister, Tara Baker, was stabbed, beaten, strangled, raped, and finally set on fire. That horrific act was not where the tragedy ended. That is where it began. Tara was an extraordinary human being, beautiful, compassionate, driven, and hilariously funny. She was the best of us. I have never known anyone with a purer heart. Tara and I were more than siblings. We were best friends. From the day I was born until the day Edrick Faust ripped her from us, we were inseparable. She cheered me on at every step. My decision to join the Air Force, my dreams of flying, it was her dream for me to become a pilot. I remember how she beamed with pride after I joined the Air Force. I remember coming home on leave and her giving me the biggest hug. We talked so much about my training and what things were like. I also remember the moment she saw my dog tags and truly understood what they meant. She grew quiet. She cried. It was the first time she ever considered that my life could be cut short. Neither of us ever imagined it could have been the other way around. Being far from home meant I was alone when I learned of her death. My father was desperately trying to contact a military chaplain to sit with me when the news came, but I called him first. The cries of anguish I made during that call haunted him until the day he died. I still have nightmares in which our roles are reversed, and I am the one making that call, hearing the pain, unable to hug my son or comfort him. I remember the fog of arranging a flight back to Georgia, the long journey home, watching people board planes and go about their day oblivious. The flight attendants offered pretzels or cookies. All I could think was, I want my sister back. The entire flight, I dreaded one moment above all, seeing my mother. When I finally reached my parents' house and I saw her face, the anguish there was something no one should ever have to witness on their own mother. In hysterical grief, she held me for what felt like days, weeping and wailing. That evening, through her tears, she begged me to achieve my dreams because Tara could no longer achieve hers. Our focus is only Tara could have inspired me to do. I made every rank as early as military regulations allowed. Eventually, I was accepted to officer training school. My family attended my graduation. Tara was not there. I went on to flight school and earned my wings. At graduation, my family proudly pinned those wings on my chest, but Tara was not there. I met an amazing woman whom Tara would have adored. We married. At the wedding, we took family photos with the whole Baker family. Tara was not in them. Every Christmas, every family gathering, every milestone, Tara was absent. She never got to be a sister to my wife. She never held my infant daughter beaming with pride as an aunt. She never cradled my twins when they were born. My oldest child has had to learn of her Aunt Tara through photographs and stories. She favors her. I mourn not only Tara, but everything that was stolen from us. Tara would have turned 49 last month. I have no doubt she would have pursued her dreams, achieved her goals. She would have married and had children. My beautiful nieces and nephews that I never got to meet. My mother's precious grandbabies who now would be old enough to chase their own dreams and start their own families. An entire branch of our family tree was severed irreparably on that one day to satisfy one man's depravity. The last 25 years should have been full of life, laughter, and generations. But the pain doesn't end here today. Despite this verdict, the pain will continue. This summer, I will retire from the career that Tara inspired me to pursue. My family will fly out. We will celebrate. There will be pictures. Tara won't be in them. She won't be there. Tara's children won't be there. Tara's grandchildren won't be there. In fact, our dad, who died at the age of 59, due to the stress and grief of losing a child, will not be there. And he is but one of a list of family members who I am certain would still be alive today had it not been for the stress, grief, depression, and utter devastation caused 25 years ago. For many years, I wrestled with God over what happened. That struggle eventually and ultimately led me to a place of forgiveness. Long before I ever heard the name Edrick Faust, I chose to forgive him. Today, sitting in this courtroom face to face, I can honestly say, I have forgiven you. I harbor no hate in my heart. I've given that all to God. You will stand before him one day. I pray that before then, you will confess, you will repent, and you will seek for the forgiveness of Christ. He will grant it. Until then, I need nothing from you except this one thing, that you never hurt anyone else again. Your Honor, I leave that responsibility to the judicial system. Please ensure that Mr. Faust never has the opportunity to harm another person. Thank you, Your Honor.
Thank you. Mr. Cruz, anything from the defense?
In regards to this witness, no, ma'am.
All right. You may call your next witness, Mr. Yellman-Chili.
Meredith Schroeder, Your Honor.
Good
afternoon, Your Honor.
Good afternoon.
During these last few weeks, we, Tara's family and friends, and all who loved her, were forced to relive this nightmare, to face the darkest time of our lives once more, to face things that we have avoided for 25 years. We sat and watched in horror the sight of her lifeless body, discarded like trash amongst the debris. We sat here in this courthouse and watched Tara be victimized once more, watched social media legal pundits co-opt our family photos as their own and opine on who they thought Tara was. I've watched as people came to spectate, like a morbid kid poking at her and us like dead animals on the side of the road. For all those interested parties, I will tell you who Tara was. She was our North Star, our champion. She was kind. She was determined. She wasn't perfect, but she was close to it. She spent her short life lifting people up and wanted to dedicate her life to making people happy. Happy law was her dream, and she had carved out her path to achieve it, and no one hated her. On January 19th, 2001, Tara woke and began her day like any other. While that day will remain the darkest of our lives, it was nothing compared to what Tara endured. I cannot imagine the fear and anger she felt, how she fought, telling herself this was not happening. While Tara was our everything, it wasn't enough for Faust. For the last 25 years, he has wreaked havoc on this community. Just 2 weeks after he ended Tara's life, he put a knife into a man's neck. He shattered another man's jaw over a parking space outside the 40 Watt. He savagely beat his wife on a cruise and then later pistol whipped her with her own gun. While we have sat here trying to maintain our composure, I've watched the defendant sleep through proceedings. I'm terribly sorry to have inconvenienced him, but you see, while he got to walk free for the last 25 years, he dealt Tara and all of us a life sentence. He stole from her, he stole from me, he stole from my children, and he stole from all of us. None of us are the same people who woke up on January 19th, 2001. Every day for the last 25 years, I have literally thought about my sister. I've wondered if her wild and tacky sister would have made her proud. I've mourned the friendship that we were building outside of sister. I've mourned the tone-deaf car karaoke sessions and the Friday night rom-coms. I've mourned the life lessons that she tried to teach me, but my dumb teenage brain couldn't understand. The guilt that I feel that I've lived an entire life that was denied her cannot be measured. I have prayed that I've been strong enough for her, that I've fought enough for her. I've prayed these last few weeks that I've done right by her. Today I stand here channeling her strength to face the man convicted by a jury of his peers to this nightmare, to let him know that after today, I will endeavor to forget his face and his name, to never allow him to cross my thoughts again. After today, I will live my life remembering how Tara lived. My final request is that this honorable court ensure that he is put somewhere where he finally ends his reign of mayhem. Thank you.
Thank you. Anything from the defense, Mr. Cruz?
Only to make 2 corrections, Your Honor. In regards to pistol whipping his wife, that is nothing that occurred or was evidence in this case.
I'll let you say that when it's your turn, but in terms of any questions you have for the
No,
witness.
absolutely
All right.
not.
Thank you, sir. You may call your next witness.
Kevin Baker.
Oh my God.
Good afternoon, Your Honor.
Good afternoon.
Thinking.
Course indulgence as I get my paperwork here. It's maybe one of the most difficult things I've ever had to do. Your Honor, my name is Kevin Baker. I'm Tara's youngest brother, who she affectionately called her baby darling. There's a 12-year age gap between the two of us, so I wouldn't see her as much as a big sister as I would see her as a motherly figure. Over the past several days, I have sat in this room and listened to people argue over semantics while thinking that my Tara, beloved sister, cuddle buddy and protector is gone. We're arguing over a Super Bowl and a World Series. Well, I can't tell you who won that game, but I can tell you every detail that happened that day. My earliest memories of Tara and I were singing Beatles songs and Elvis songs and having a dance party in the living room. We watched old movies like Wizard of Oz and the Braves game on TV as we would cheer on her boys to victory. I even told her as a young boy I was going to play baseball and I was going to be just like Chipper Jones, who she adored so much. She would sit there as I would tell her that, and she would smile and say, "You could do whatever you wanted to do as long as you put enough effort into it." To help me sleep, she would tell me Bible stories and hold me close when I was scared of the dark or when things would go bump in the night. Everywhere Tara lived, she invited me to stay at her house. From her dorm at Georgia College to the 80 Pie house, I was always welcome, where most college girls would think having a 9 or 10-year-old little brother following them around a college campus would be annoying and maybe even a bit embarrassing. But she saw it as an opportunity to connect and show me how doing well in school can benefit you. I remember the last time I saw her. It was towards the end of Christmas holiday. Adam was home, and she thought how great it would be to have a siblings' day out. She took us out, myself, Adam, and Meredith, to Chick-fil-A for lunch. We laughed, we carried on, and had a great time as a family. It was probably my last true happy memory as a child. She said goodbye to me in the driveway. She bent down on one knee and gave me the warmest hug in a white turtleneck sweater and a brown leather jacket and a kiss on the cheek. She told me to do my best in school as a new school year would be starting. In a few weeks, she would be back to visit with just me. She planned to come home and visit with me and go to my baseball game. I started that next school year with just the focus on school and sports. Then came Friday, January 19th, 2001. I was taken out of school, oblivious to what was happening at the time. My parents were in a panic and dropped me off at my grandparents, who would soon drive me up to Athens. But before we made our way to Athens, I asked my grandparents if it would be okay to get something to give to Tara as a gift. My grandparents, already knowing what was happening in the situation, couldn't bear to be the ones to give me the news. So they took me to a Hobby Lobby. I got a dolphin figurine and I made it for her, not knowing that she would never receive it. I arrived at the Holiday Inn right down the road from here. As a child of only 11, I was given the news by my late father that there was a fire at Tara's house. My immediate response was, "Is she in the hospital? Tell me she's okay." My dad stood there, choking back tears, saying, "No, buddy, she didn't make it. She's gone." At that moment, my childhood innocence was destroyed. It would be shadowed by grief and running around this college campus with flyers asking who killed my sister, asking questions, not knowing anything other than she was gone. Learning words that no elementary school kid should ever have to learn or know happened to his big sister. Words such as rape, stabbing, arson, and murder. Kids at school would say, "We're sorry for your loss." I was only thinking to myself, I didn't lose her. She was stolen from me. Where most kids would come home to a warm house full of happiness, I came home to a house, despite my parents' best efforts to create the best environment possible. It felt more like a mausoleum than a warm home. Unlike my siblings, I went through the majority of my life from childhood, teenage, and adult phases without Tara. Unable to ask her, "Am I doing okay? Is this what I should be doing in school or in life? Would you be proud of the man your baby brother has become?" I strived to be just like her throughout my childhood. When I received awards, graduated high school, and graduated college, Tara was not there. When my father died, which this murder took years off of his life due to stress, instead of Tara holding me while giving me the news of my father's passing, I fell to my knees in a hospital parking lot at midnight alone to collect myself and be strong for my mother, who was already in the ER room waiting for me to arrive. I found love and married, and instead of a family being in the front row, I had 2 empty chairs with 2 white roses for both my father and Tara, who would have been there if the situations had been different. As this trial goes on, I have read and seen the absolute best and the absolute worst of people in both this courtroom and outside who seek to turn a sensitive matter into a circus of calamity and pandemonium for their own entertainment, for likes on their social media pages, all the while seeing how this trial has opened up old wounds and exposed horrible memories. I have heard how this man is sitting here fighting for his life. Well, it makes me think about something about that morning. Did Tara have a chance to fight for her life? Who was there at the moment when she needed someone the most? No one, because she was scared and she died alone. Your Honor, I've listened to details for the first time that I've never been told about this case, not because the case was not thoroughly investigated, but because of the horrific and gruesome facts that my family tried to shield from me due to the age at the time. Your Honor, when that verdict was read, the person that's sitting here in that pew that day is not the 36-year-old man that stands before you right now. It was that 11-year-old boy who brought back all that pain and loneliness of being in that hotel room, knowing that his sister had just been killed. As a father of a young girl, I dread for the day that I will have to give the tale to my daughter of her Aunt Tara, not for being the loving aunt who would have loved her so much or strived for greatness, but as a cautionary story of safety, because someone thought that they could play God and decide who should live and who doesn't. I've taken my grief and I've used it as a career to help others during their time of loss and guide them through their grieving process. It gives me peace to know that none of these families that I will undoubtedly have to help in the future will not be caused by this man's reign of terror in this community. I pray that there will not be another family in this community that will have to deal with the same pain and sorrow and cruelty that we have had to deal with over these past 25 years. This is not the final chapter of Tara's story, because once this case is concluded and her story will live on in everyone who ever knew her and everyone who ever loved her, despite this man's best efforts to destroy her legacy and destroy her body, she will endure in our hearts forever. For those who are in this courtroom or maybe watching at home, I ask you this: will you remember her? Because she would remember you. Thank you, Your Honor, for your time.
Thank you. Anything from the defense, Mr. Cruz, of this witness?
No, ma'am.
All right, thank you. You may call your next witness.
Your Honor, we don't have any other witnesses. We're ready to make our recommendation at this time.
You may proceed.
Thank you, Your Honor. I cannot offer anything more important or more impactful than what Tara's family has already said, and I will not try. The court has heard the evidence in this case and all its brutality and depravity. It's horrific, even in the context of other murder cases. The state's recommendation in this case is as follows. On count 1, a sentence of life imprisonment. On counts 2 through 5, vacated. Count 7 would be 30 years confinement concurrent with count 1. Count 8 would be life consecutive to count 1. Count 9 would merge with count 1. Count 10 would be 30 years consecutive to counts 1 and 7 while being concurrent with count 8. Count 6 would be 20 years consecutive to counts 8 and 10. Count 11 would be 20 years consecutive to count 6. And count 12 would be 5 years consecutive to count 11. The total sentence would be 2 consecutive life sentences plus 45 years of confinement with 60 years of non-parolable concurrent confinement with those 2 life sentences. That's the state's recommendation, Your Honor.
All right, Mr. Yeoman, you went through that very quickly, so I'm actually going to ask you to go through it slowly so I take down what you say, and I will do the same, of course, for Mr. Cruz. If you'll do it a little bit slower for the court, I want to make sure I know what you are asking for, and then I'll do the same for Mr. Cruz.
Yes,
Start
Judge.
with count 1.
I will. And just for an overall, again, in total, we're getting to 2 consecutive life sentences plus 45 years of confinement with 60 years of non-parolable confinement concurrent with those 2 life sentences. And the way that we structured that was in count 1, life. Counts 2 through 5, vacated. Count 7, 30 years concurrent with count 1. Count 8 is life consecutive to count 1. Count 9, the aggravated assault, merges with count 1. Count 10 would be 30 years consecutive to counts 1 and 7 and concurrent with count 8. Count 6 would be 20 years consecutive to counts 8 and 10. Count 11 would be 20 years consecutive to count 6. And count 12 would be 5 years consecutive to count 11.
Thank you.
Thank you.
Anything else from the state?
No, Your Honor.
All right, thank you. Mr. Cruz.
Would you like us to start with mitigation before we get into sentencing?
Yes, certainly you can. If you are presenting witnesses, this would be the time to do so.
All right, thank you. Your
Thank
Honor.
you.
I had a lot of inquiries, if I may. If you're here to testify on Mr. Faust's behalf, can you raise your hand for me? All right, you all come up to the front real quick.
Mr. Terrell, can you help with the podium here? And then maybe we'll put a microphone, put it in between the tables. That would be very helpful. Thank you.
Your Honor, the first witness that we have is Miss Kinsey Faust.
Good afternoon. How you doing?
Good afternoon.
My name is Edrick Faust, and I'm speaking on behalf of my cousin, brother, Edrick Faust. And the picture that being painted as a monster, he's no monster. He's a human being. He has family that loves him and care for him. With all this, I want justice to be served, and just to be served the correct and right way. And all has been said and presented throughout the court system. I've been here day one, ever since Mr. Faust got arrested back in 2023, whenever it was. Like I say to this day, I want the Baker family to get justice. And I feel that justice was not served. And I feel that they're painting a picture of Mr. Faust like he's a monster. He's no monster. He has family, grandkids, kids, and all. And he has lost people also. My father, which is his uncle, which helped raise him. And I know my father raised me, and my father did not raise no animal, nor monster. And I ask you, Lisa, today, as you get ready to sentence Mr. Faust, to really look at the justice and the way things should be laid out. Because Mr. Faust, my cousin, I love him. My brother, we raised in the same house, like I keep saying. He's no monster. He's a human being. And things that happen to Tara, I'm a female too. And I hate all of that. But I would like for justice to be served, and to be served the correct and right way.
Thank you. Ms. Gialmachilli, anything from the state?
I don't have any questions, Your Honor.
You may call your next witness.
Your Honor, next we have Mr. Bryson Shields.
How you doing, Ms. Lisa Locke?
Good afternoon.
I know E. I used to walk car with him.
You'll pull that microphone out.
I'm sorry. I used to walk cars with E. And like in last witness, he's not no monster, man. And I'm sorry for what happened. But justice wasn't served here. So that's all.
Thank you. Ms. Gialmachilli, anything from the state?
No, Your Honor.
You may call your next witness, Mr. Cruz.
And I'd like to make a statement for on behalf of Mr. Faust. I know it's unique for the attorney to do so.
Go ahead, sir.
But Your Honor, you're aware that obviously our system is a system of laws. And once the jury renders a verdict, regardless if we agree with it or disagree with it, that's the law we follow. That's the procedure we follow. I would ask the Honorable Court to consider in its sentencing, and we know what the mandatory sentencing is in this case, but we would ask the Honorable Court to consider things that took place in this case. As the Honorable Court is aware, and obviously we don't relitigate issues, Mr. Faust didn't have opportunity to explain his DNA. Mr. Faust didn't have opportunity to argue consent. There were things, and throughout this trial, I spoke the truth this entire trial. Not one time did a dishonest statement come out of my mouth. But as I advised the Honorable Court, I've reviewed every piece of discovery in this case. And this case is a true tragedy. The very first time I stepped in this courtroom, Your Honor, I said in order to get justice for my client, I would have to get it for the Baker family. And obviously I failed at that. The jury decided otherwise. But Your Honor, I presented the evidence that I could present to the Honorable Court, to the jury as well. I am aware of the mandatory sentencing schemes, but I do know the Honorable Court at the end of this and upon sentencing typically gives its own proffer or statement to the defendant in regards to the Honorable Court's thoughts and the reason it's given the sentence that it is giving. I would ask the Honorable Court if it would consider this is a case of very unique circumstances. And obviously, the evidence that we presented again, the jury, as the finder of fact, found that our theory was not the truth. But I would just ask the Honorable Court when it renders its sentence to give the lesser on the lesser end, even though it's mandatory, but also in regards to the Honorable Court's statements to the defendant or Mr. Faust, which will come. I just asked the Honorable Court to keep everything in mind because Your Honor is aware of a lot more than I was able to present to the jury. And that's all I'd like to say to the Honorable Court. To the Baker family, this is a heartbreaking case. And as an advocate in this case, no one, the state and I would disagree completely, but no one would ever say that this wasn't a tragedy. And I give my heartfelt, and I mean my heartfelt from the bottom of my heart, my heart goes out to you all and what you've been through. But Your Honor, I just ask you to consider that when it comes to your statement to Mr. Faust at the time of sentencing. Thank you.
Thank you, Mr. Cruz. Do you have any specifics with regard to counts 1 through 12 you'd like for the court to consider?
I do. My other two witnesses just arrived, Your Honor.
All right. You may present your witnesses, sir.
Hey, my name is Katrina Faust.
Good afternoon.
Edrick Faust isn't a monster. He is a very lovely, funny, and hardworking person. Edrick will always be my cousin, my brother, and I ask God to protect him. I pray to God to give him strength every day and to keep his mind together. And his family will keep fighting for justice for him. Edrick Faust isn't the killer. He was accused as the killer, but he isn't the killer. And he also have a family that love him. And we're going to keep fighting for justice for him as long as it takes. And I'm sorry for the Baker family. And I'm sorry for my family had to keep grieving over this. Because it's been very hard for the Faust family too.
Thank you. Anything from the state, Mr. Yelmichilli?
No, Your Honor.
You may call your next witness.
Okay.
My name is Shonda Smith, and I would like to speak in reference to my cousin. I'm his first cousin, Edrick Faust, and I would like to say, Your Honor, my name is Shonda Smith. I stand before you today on behalf of my cousin, Edrick Faust. This is an incredible, difficult moment for our family. We are watching someone we love face sentences while firmly believing in our hearts that he is an innocent man and he has been wrongly convicted. Edrick is more than what has been presented in this courtroom. He is a son, a father, a cousin, a brother, a man of faith who has always been a source of support in our family. This man, he knows the kind, he's compassionate, and he's deeply valued by those who truly know him. As a family rooted as our family rooted in faith, we believe in justice, but we also believe in mercy, grace, compassion, and the truth. God sees what we cannot see. God knows what we do not know. We humbly ask, as you determine the sentence, we consider his character, his strong support system that stands behind him. And I hope that this still remains in his future. If you could see his future as a loving, bright, intelligent man. Thank you for allowing me to speak. As I do love my cousin, I hope the Baker family finds justice, because this is not it. Thank you.
Thank you. Anything from the state, Mr. Yalomachili?
No, Your Honor.
Mr. Cruz, any other witnesses?
No, ma'am. Just discussion regarding
All right.
One more, Your Honor.
Go ahead, sir.
Good afternoon. My name is Tijuana DuBose.
Good afternoon.
I stand here today heartbroken, not just for Edrick, but for the Baker family. I have witnessed this for the last couple of years, and it's very heartbreaking. I'm sorry what has happened, but I just ask that you guys just look at my cousin as not being a murderer, because he's not. I understand that something did happen, but he wasn't the one that did it. I understand the Baker family would like to have peace and justice for what has happened to their daughter, but at the same time, you have the wrong guy. If I wasn't here myself, if someone told me what happened, I would say, this is not true. But I witnessed everything, and the things that I witnessed, I can say everything was wrong. Everything was done wrong here. I understand people had a job to do, and they want to protect themselves and their job and their family. But at the same time, it's two families that did not get justice. Edrick Faust family did not get justice, and the Baker family still don't have justice. So I just ask that God continue to step in, to guide us and lead us and direct us to the right person that did do this. But as you guys do what you have to do, you have the wrong guy. And I stand here today and I firmly agree on what I say. I'm the first cousin of Edrick Faust. We grew up together. I knew him. I'm 48 years old. We're just a couple of years of difference. But I've been here and I know the things that Edrick done. Our grandmother has been in our lives, and Edrick is a good person, but I'm not going to say everything he has done in his life has been good, because everything I've done has not been good. But at the same time, I don't feel like you should get punished for something that you didn't do. So I just ask you guys to just do what you have to do, but at the same time, know that God has the last word.
I love you.
Thank you. Anything, Mr. Yalomachili, from the state?
No, Your Honor.
Anything else, Mr. Cruz, in terms of witnesses?
No, ma'am.
All right. And anything else you'd like to tell the court with regard to counts 1 through 12, just
Yes,
as the
ma'am.
state did? Go ahead.
Yes, ma'am. Your Honor, I ask the Honorable Court to exercise its discretion. I understand in count 1, malice murder, the jury found Mr. Faust guilty of malice murder. And the Honorable Court, the only option the Honorable Court has is life with or life without parole. We would ask the Honorable Court to, in regards to count 1, for the lesser sentence, which is life, the lesser sentence, which is life with parole in regards to count 1. Counts 2 through 5, those vacate as a matter of law. Count 6, our request is a 1-year sentence on the burglary, Your Honor. And as the Honorable Court is aware, and I stated before, our system is a system of laws, and we have to respect the jury's verdict. The reason I'm asking for 1 year on the burglary count, Your Honor, is based on evidence that the Honorable Court heard, which is the state providing to the jury that they couldn't show that Mr. Faust or how Mr. Faust got into the home. The Honorable Court could weigh the evidence in regards to the burglary charge. The Honorable Court is aware, and the Honorable Court can make a decision as to whether or not the evidence was overwhelming that Mr. Faust broke into Ms. Baker's home. So that's why we're asking for 1 year on the burglary count to be served concurrent. That's count 6. Count 7 in regards to aggravated sodomy, and that was the oral sodomy. The Honorable Court's discretion is only from 25 years to life. If the Honorable Court issues a sentence of 25 years, I believe the statute requires that the remaining portion, if I'm not mistaken, is remainder of probation for life, if I'm not mistaken. So I'm asking the Honorable Court in regards to the aggravated sodomy oral for the lesser sentence in regards to the court's discretion, which is 25 years, I would ask that that sentence is concurrent to count 1. And if I didn't state it with count 6, I'm also asking the 1 year is concurrent to count 1. In regards to count 8, Your Honor, I believe count 8 and count 10 merge based on the language of the indictment. The language of the indictment provides that the basis for the rape in court's indulgence the indictment specifically alleges that Mr. Faust had carnal knowledge of Ms. Baker. However, when it comes to aggravated sodomy, which is count 10, which is the anal charge of aggravated sodomy, carnal knowledge includes anal sex, his sexual organ entering Ms. Baker's sexual organ. So we would say that count 8 and count 10 merges. In regards to count 10 merging into count 8, Your Honor, the Honorable Court's discretion is only 25 years to life, similar to count 7. We would ask the Honorable Court to exercise its discretion and sentence on the lower end, the 25 years with probation for life. We would ask that that is concurrent to count 1. In regards to count 9, aggravated assault, the Honorable Court is aware that the sentencing range is 1 year to 20 years. We would again ask for the lower end of that range, which is the, no, please forgive me. Aggravated assault merges into count 1 by law. So please forgive me. Count 9 merges into count 1 by law. As I mentioned in count 10 merges into count 8. Count 11, arson, 1 through 20 years. We're asking that the Honorable Court exercise its discretion and sentence Mr. Faust to 1 year concurrent with count 1. And in regards to count 12, I believe the statute does not give the Honorable Court discretion in regards to the sentence being consecutive. And I believe it's a 5-year consecutive sentence to count 1. So the total sentence that we're asking for is life with parole plus 5 years, which is the mandatory minimum that the Honorable Court could sentence Mr. Faust to. As a significant piece of the mitigation, as I mentioned, Your Honor, is that I hope the Honorable Court takes into account the evidence that came out in this case. I do believe when Mr. Faust was initially arrested, it caused an uproar in Athens because a lot of people assumed that, hey, we've got the right person. It's just based on this new technology that the GBI had. But once we came into the courtroom, Your Honor, the jury, the Honorable Court, and we respect the jury's verdict, I'm not relitigating that, but the Honorable Court, in regards to mitigation, heard significant evidence that was never stated before in regards to Mr. Melton's involvement in this case, in this crime, which was rejected by the jury, which I acknowledge. But the Honorable Court is also aware of the rulings that were adverse to the defense. And I'm sure the Honorable Court says, hey, it was 412, it was 412, it was 412. I respect the court's ruling. I disagreed on the record. But Your Honor, you could take everything that came into this case, all the information that came out in this courtroom, and you can make two choices. You can either say, hey, there were some questions in this case. By law, I'm required to sentence this way. I am going to use my discretion and sentence him to the lower end. It's still a life sentence, Your Honor. Or the Honorable Court could say, hey, I heard the information that came out in this case. I reject all of it, and I'm going to sentence him to what the state requested, which is the maximum sentence on everything. I am not from Athens. However, this case has caused a divide in Athens. Just like I witnessed, the Honorable Court had the opportunity to witness, this courtroom was split down, and I hate to even discuss it because it's a difficult topic to discuss, but the courtroom was split pretty much down racial lines. The Honorable Court had concerns and discussed social media with both counsel. I didn't look at social media until after a verdict was rendered in Mr. Faust's case. And the damage that this case has caused in the Athens community is mind-blowing. There's some people extremely upset. There's also some citizens that are extremely relieved. But Your Honor, in your position, you have the power to send a message, whether that's, I'm going to give Mr. Faust the absolute worst sentence he could get, or I'm going to take into account everything that came out in this trial, and I'm going to sentence him within the guidelines as required by law, but I am going to sentence him to the minimums, and that's what we would ask, Your Honor. And I thank you so much for your patience.
Thank you. Mr. Lomachelli, do you care to respond to the argument by counsel about merger of count 8 and count 10?
Yes, Your Honor. I mean, count 8 and count 10 do not merge. The carnal knowledge is defined in the rape statute as penetration of the vagina by the penis, and it doesn't merge with aggravated sodomy. I know I don't think any of the ranges that Mr. Cruz gave were based on statutes as they existed in 2001. I think he's going off the statutes as they exist currently. I think it's incumbent upon the state in our role in the process to point out that given that it's a murder from 2001 and no notice of intent to seek death was filed, it's not a death penalty case. Mr. Faust can't be sentenced to life without parole. I believe the maximum is life because the statute was changed subsequent to when the crime was committed in 2001. So I do want to point that out. Also, as far as the 25 to life range, again, by our review of the statutes, that's not correct. On the rape, I believe it's 10 to 20 or life. And on the sodomy, I believe it is 10 to 30 or life. So I do just want to clear up those factors. I think that's a misstatement of the law. And I'm not going to respond to some of the other things that Mr. Cruz said. Obviously, the court knows what it ruled and didn't rule, but I don't think those are accurate statements of the way the proceedings were conducted.
Thank you. Anything further, Mr. Cruz, about the issue of merger?
Sure. If I could have a second to look at the statement, the law, and it should take maybe a minute, 2 minutes at most to look at the law in regards to what statute applies at the time of sentencing or at the time of. Thank you.
We have a minute here. Typically, isn't it the law as it existed at the time of the crime, Marie?
Yes.
Right? So it would go back to 2001, whatever the law in 2001 was?
Yes.
With regard to sentencing guidelines. Any thoughts so far on what we've been observing here?
I think Edrick Faust's attorney is speaking to a brick wall, and she's basically being requested to reverse her own rulings throughout the trial, and that's not going to happen. I think there's a lot of information that the public is not privy to in reference to whatever pretrial hearings took place to determine what the defense can argue. And based on what he's saying, Edrick Faust's attorney, Ahmad Cruz, there was an issue of consent. And what I'm hearing without being there during the pretrial litigation is there was an issue of consent that they weren't allowed to raise.
Right.
So that sort of answers my question to you off record. Why didn't he testify, right? Because that's a strong defense if you're saying, you know, if my DNA was there, right?
Yeah.
It's because I was there with permission.
The state is correct.
wasn't
The
allowed.
statute at the time of sentencing. If I could have a second, Your Honor, to look at these statutes, I looked at the current law and applying the sentencing ranges. The Honorable Court would allow me to look at the statutes at the time of in 2001, if that's okay.
Okay. Thank you, Mr. Cruz. So, ladies and gentlemen, I'm going to adjourn. I'm going to consider both parties' arguments to the court. That'll give you time, Mr. Cruz, to look at the statutes. I'll be back on the bench shortly. I do want everyone in the courtroom to know that the Sheriff's Department is in charge of the courtroom. And if they ask you to remain seated while they allow other persons to enter or exit, they are allowed to do that. I'd certainly ask for your cooperation. They are in charge, again, of the courtroom. I'm going to be adjourned for just a little while. I'll be back on the bench. And Mr. Cruz, if you have anything else you'd like to add with regard to looking at the statutes at that time, you may do so.
Yes, ma'am. Thank
All
you.
right, thank you.
Oops. Well, I totally understand if you have to go. I've already kept you here for an hour and a half. So I don't want to force you to sit here any longer if you have other meetings or anything to do, but we love having you here.
Oh, listen, if you want to talk some more, I'm open.
Yeah. I mean, we can talk while she gets off the bench. A lot of people feel like she's already made up her mind and she knows what she's going to do.
But you know, the good part is I just want to go back again, talking about the life that was lost, right?
Right.
Regardless of how divided social media, the people in the audience, and the world is about this case, a life was lost, right? That was somebody's daughter. We all heard the victim impact statements, and I was crying like a baby. I apologize for that.
No, it's usually me crying.
No, it's just awful what happened to that poor little girl. I'll call her a little girl because I'm old enough to be her mama, okay? But, the family says, people are ingratiating themselves on their tragedy. I want to speak for myself and for you. Actually, we're not. We're legal analysts, right? And so my opinion is based on my legal analysis. It doesn't mean I don't have a heart. It doesn't mean that we don't understand what happened to this little girl and the lasting pain it caused her family. All we're saying is we're looking at the case structurally, and we're looking at the law based on our American justice system. And there is something called beyond a reasonable doubt. So the fact that you may be saying they didn't prove their case beyond a reasonable doubt, and we're pointing out facts that we saw in the case, because thanks to Law and Crime and Court TV and people like you, this is not done, behind a shadow. We saw the witnesses. We saw the empty envelope. We saw the broken piece of slide with DNA in it, secured by tape. Law enforcement witnesses stated, we told him, was it 10 days or 3 days, and what the ramifications would be. Nobody made that up. We're arguing that there was no proof beyond a reasonable doubt based on what we saw. At the end of the day, we want to be 13th jurors, but we weren't. And the jurors decided for whatever reason. But that doesn't change the fact that, in spite of the fact that I was bawling when I heard how hurt the family is. I mean, I'm a woman. I have daughters. I'm a domestic violence victim advocate. But that doesn't change the fact that there's a burden of proof. And based on what Edrick Faust's attorney is saying, there was some back type of hearing where they decided, the judge, that they would not let him speak on anything concerning consent. And I'm not even saying if they allowed him to speak, it would be true. That's not what we're talking about here. I'm not saying anything about her personal life and whether or not she slept with him. That's not what I'm saying. I'm saying it wasn't presented, and the testimony that was presented doesn't support, in my professional opinion, and yours too, proof beyond a reasonable doubt. Doesn't mean my heart doesn't go out to the family. It's just we didn't get to hear the whole thing because he didn't take the stand, but he has the right to remain silent, right? So maybe his lawyer said, you know what? I'm not even going to put him on. They still could have put him on, but what would have happened is they would have brought out all that shit that he did before he got arrested. And let's be clear, he wasn't a good guy.
Right.
They're alleging he stabbed people. He was selling drugs. He was violent. And one could say they would open the door to prosecutors questioning him on his violent past. And it would just make the jurors think, okay, he has propensity for violence, so he stepped into rape. That's all. He was a bum. He was selling drugs. He was stabbing people, getting into fights. He has a long rap sheet, so he could have done this too. So that's why they didn't put him on the stand, because that's what we discussed off record. I said, right. Melanie, why didn't he take the stand? because if he did, he wasn't allowed to even say his defense of consent. And I'm not saying there was consent. Let's be clear on that. But he never could even say that. So if he took the stand, he would have just opened himself up to cross-examination, and the jurors would have known about his past, which wouldn't have helped at all. But sometimes, even, when we have the right to remain silent, there's something in contract law, and you know this because you're more like a civil litigator too, on top of being a crime sleuth, right? Sometimes silence is acceptance. So if I'm saying you did it, and I don't get on the stand, even though the Constitution says I don't have to, the jurors are people like anybody else. So they took his silence as acceptance, but he only stayed silent because his only defense, the judge said, zip it.
Right.
And if his lawyer said one thing, they charge him $1,000 for even bringing it up.
Right.
So they just had to shut up. But the good thing is, you know what? There's something called appeal. And let me tell you, Ahmaud Cruz didn't leave one area not to be appealed.
Right.
He might have sounded like, okay, you said it already. Shut up. You're going to get her mad. He was making his record, people.
Right. Right. And every single time
going to be appealed. And whatever took place in that 412 hearing that made her say, shut up, you can't say anything about consent, doesn't sound right to me. Because yes, there are rape shield laws to protect the victim because you don't want to dehumanize the victim, say she was looking for it, this and that. But if the consent is part of your defense and there's proof, it's not nothing crazy. The judge is not going to like, she consented. But if there was dots of circumstance to connect with that allegation of consent, right? Then they should have let it in. This case is going to be litigated, and I suspect whatever ruling she made that prevented him from talking about his one and only defense besides the third party culprit, we might be right back here again, and it has happened before.
Yeah. Yeah. The problem is it takes years. As you know, it takes years. This is a great comment. More K123 says, I feel the jurors were swayed because of CODIS. They knew exactly what that meant. I mean, Ahmaud Cruz fought to keep out any mention of CODIS. And again, he was hamstrung and the judge allowed it. And anybody who watches true crime, anybody who's ever watched a trial knows that CODIS is for convicted felons. And so they're thinking, okay, if he's in CODIS, that means, he's already a convicted felon. That's how they got their hit on him. And so he must be guilty. People don't understand burden of proof. They don't understand reasonable doubt. I mean, the people who watch this channel too, because we hammer on it all the time. But, that's just one of the issues I feel on appeal is that it was highly more prejudicial than probative to allow them to even use the word CODIS as the national database for DNA. One of the many. And if nothing else, Ahmaud Cruz made an amazing record on appeal. He had case law with him. He had statutes with him. He read the statutes into the record. He read the citations for the cases into the record. And she was visibly, mad at him every time he got up there to make an argument. But I think he felt like he knew where this was going and he had to do that.
And he continues to do it until the end, even with sentencing. Right. Even with sentencing, he micromanaged the entire thing. He seemed like he was nitpicking, beating on a dead horse, but he wasn't. Because even with the sentencing, if they didn't serve him with the 10-day notice that they were going to use all of what they're using against him, his prior recidivist criminal history, which they're asking the judge to give it to him, nail him, because he has this, he has that, he has this. There's a law that says you need to tell me what you're going to use, what prior bad acts and convictions you're going to use so that I could be prepared to rebut. And they didn't do it, not for all of them.
Right.
So he put it on the record. She ended up, not agreeing with him. But it doesn't matter if she didn't agree. The fact is he put it on the record, and that is what is important.
Right. I mean, another thing is that this judge sat on many of his prior cases and his prior convictions, not just this one. And so he was already well known to this judge for his priors, his probation violations. And all you need to do is go into the court docket. It's huge. and see all the cases of his that she already sat on. They made a motion to recuse her. That was denied. It was just one of the many motions, a pretrial here. The motions to suppress evidence, motions about phone records. I mean, there's so many issues here. I haven't even had a chance to read the entire docket, but one of the victim impact statements talked about him pistol whipping his wife on a cruise. Nobody's ever heard of that before. That was wild. And I have sympathy. Both things can be true. You can have sympathy for the family,
Yes.
and feel that they have every right and get, because that's what victim impact statements are. It's a time for them to get up and talk about how this has affected their lives, right? And their lives have been devastated. That poor boy, this happened to him when he was 11 years old. He's never had the opportunity to have a normal life, because so many times, as you know, when a sibling dies or a child dies in a family, the family dynamic totally shifts, and all of the attention is now on the child that was lost. And so the other children are often lost in the shuffle of everything that goes on for the next 25 years. And it's devastating what happened to this family. And we can feel both things. We can feel empathy for the family, and we can feel empathy for Edrick Faust, who, in my opinion, there was not enough reason. There was so much reasonable doubt that I was surprised by the verdict.
And that's the operative word here. There's a burden, and it's beyond a reasonable doubt. No one is saying that he's an innocent man. At least I'm not. What I'm saying is, the way the case was provided, they didn't prove beyond a reasonable doubt that he's the person who committed this act. And I strongly believe on appeal, there are a lot of very serious appellate issues that may be upheld, and they may order a new trial for him.
Right. Right. Once again, the Give, Send, Go for the appellate fund is pinned in the chat. If anybody has the means and the desire to donate, appeals are expensive. Appeals are expensive. Think about the trial transcript. 9 days of transcripts, 10, 11 days maybe of transcripts. The appellate record, the printing alone for an appeal, is tremendously expensive.
Very.
There are no winners here. There's a lot of love for you in the chat.
There are no winners. There are no winners here. And our hearts go out to the families, because, her family suffered a catastrophic loss. They live with it till this day. Like, you can never take away the pain that they're going through. Because at the end of the day, we know death is a part of life, but death at 24 years old, the day before your birthday, after being raped, sodomized, burned, stabbed, and strangled, that's not a natural death. And I think her mother will never get over that. Her father died, never getting over that.
Right.
But we're here to analyze a case. And based on my opinion, they did not prove the charges against him beyond a reasonable doubt, based on all the information that was presented at trial. But we respect the jury's verdict, but there is an appellate moment that is soon to come, and let's see what happens there.
It's
Pray for the families.
What's that?
Pray for the families.
Oh, pray. Yeah, pray. Ed's girlfriend says, I believe the judge's bias likely swayed the jury. I mean, nearly all of the defense's objections were overruled, and the state rarely got overruled. Made Cruz look incompetent to the jury. I don't know how much of the trial you watched, but it was like the two of them, between the DA, Mr. Yalamanchili, and the judge. Every single time he made an objection, they would say, well, I don't understand. What do you mean? And they tried to make him look green and incompetent and like a novice and like a kid who had no idea what he was arguing. And I think that came across to the jury, and maybe they felt that way too, because they're not lawyers.
Yeah, because if you are an attorney, you will give him his flowers, the entire team. He knew the rules of evidence. Oh my God. He had case law. He knew the rules of when to object for what. And then even when she ruled against him, he was able to come back.
Right.
He's an intelligent person who was well prepared. And I'm telling you, my hat goes off to him and his entire team. So I don't know, who thought he was green, but no, not at all.
He's taken a beating online over it. And I think he is and has remained a gentleman throughout these entire proceedings. Coming into court the day after she fined him $1,000 and still showing respect to the judge, never really losing his cool. I mean, it's hard, isn't it? Being a trial lawyer, it's hard.
It is very difficult. The case reminded me of an old case, not that old. The attorney's name on that case was Jeremy McClyman, also a very young attorney. And it was the case of Florida against Alicia Andrews for the murder of a rapper, Julio, right? And he had a really contentious relationship with the court. And she ended up not being convicted of the top charge, but she ended up being convicted of manslaughter. And right before the sentencing, which was supposed to take place on December 8th, because she was convicted for manslaughter, he went to appellate court and he filed a motion to have the judge removed from being the judge to make the sentencing decision, even though she was the judge who heard the case. And you know what? He won. He had all of this video from Court TV and the pool cameras of the judge berating him, his team, and whoever heard the appellate motion did their homework, and they took the judge off the sentencing roster, even though she was the judge who heard the case. Very rare outcome, but appellate courts pay attention. And you're right. She belittled him. She ruined his credibility in front of the jurors. She tried to clown him. And all of that impacts the jurors, whether they know it or not. Right. So hopefully on appeal, these are things that are going to be taken into consideration. And we have the receipts. Thank you to people like you, people like Law and Crime, Court TV. It's all there for us to watch. The demeanor of the judge, the tone.
The judge and the prosecutor. And, there was only 48 hours between the jury verdict and sentencing here. Sometimes, the sentencing is 3 weeks away. Some states do a PSI, right?
I was very surprised that they didn't do that, because in most cases that I've had, they send somebody from the Department of Probation, they speak to the defendant, find out if there's remorse, if there's, any possibility for rehabilitation, is he accepting responsibility? They talk to family members, they talk to the crime victims' families and everything. This was like speed, like microwave sentencing.
Right. Right. Maybe they don't do a pre-sentencing investigation in Georgia. Maybe it's not an option, because I didn't even hear them ask for one, or I didn't hear the judge ask the defense attorney if he wanted one. But in many of the trials that we watched, it's been months, or it could be weeks between the verdict and the sentencing. And they just want to put this case to bed. They want to close another one. And my fear is that this is going to open the floodgate on cold cases, because now that she's allowed some of this testing into a Georgia courtroom, it's going to be precedent. And there are going to be other cold cases that may also lead to convictions on, maybe mishandled evidence, bogus DNA evidence. I mean, partial DNA evidence.
You know what? Let me put on my defense attorney hat and play a little bit of devil's advocacy, right?
Mm-hmm.
I get all the issues with the DNA, but is it really the judge's role to say they did the DNA improperly, the storage was off, too much time went? Is that her role as a judge, or is it the role of the defense attorney to bring that out on cross-examination and let the jurors decide whether or not the fucked up DNA, the old DNA, the taped up DNA, the empty envelope DNA, the statements made by that detective, basically telling their person of interest, Mr. Melton, what time frame to say when penetration took place between him and his girl. Is that all something that the judge needs to step into, or is it beyond her role as a judge? Because this is litigation, right?
Right.
So, and the jurors are the trier of fact. So I think a lot of her objections of him saying you need to suppressed that evidence because of the integrity of the DNA. And the judge was basically saying, it's not my role to suppress shit. It's your role to make the jurors understand that it was tainted, and then they decide whether or not that taintedness made a big difference on whether or not your client did it. Maybe, that's a position the judge took. He wanted the judge to strike the evidence of the DNA because it was old, dusty, improperly stored, chain of custody. But these are arguments you make when you cross. So if your cross is effective, then you convince the jurors, and maybe he just didn't convince the jurors. That's my defense attorney hat.
My defense attorney hat would be, it is the judge's job to qualify an expert and who's permitted to testify as an expert. And when you allow a young girl who's never testified as an expert before from California to come in and testify about a test that has never been used in a courtroom before, because it's junk science essentially, and it's never been allowed in a Georgia courtroom before, she does have the last, she's the last line of defense of qualifying an expert. And, there are requirements under Daubert, right? On who can testify as an expert. And we both know that juries look at experts like they are more qualified than other witnesses. And so their word is gospel. Whatever the expert says, well, they're an expert, right? So it must be right.
Let me come right back at you, Miss Melanie, not so little, right? Why didn't they bring on their own experts? Because it's usually a battle of the experts. If you think the expert was too young, too dusty, don't know what the fuck she's talking about, bring in somebody else who could knock her off her keel and convince the jurors to go with your expert's opinion. That's what it's called, litigation.
No, I agree, but I'd have to look at the pretrial motions to see if that his expert witness might have been precluded. I don't know. I honestly don't know. But
we don't know. I think there's a lot of things that we don't know, just like the jury did not know about the possible consent theory.
Yeah.
And that would have made a big difference, I feel, because it would have explained the presence of his DNA. If in fact they wanted to believe the DNA evidence was valid, then he would have had an opportunity to explain why it was there. Snarkastic. Oh, I didn't get to read that, but
I think it said, I think the judge limited or precluded an expert on the
okay,
defense
there
side.
you go. There you go. But these are all things, snarkastic, that are going to be reviewed on appeal.
Yeah.
Don't worry, because nothing he argued for Ahmaud Cruz, that they shot him down and made him look silly and young and don't know what the hell he's doing. All of that is still up on appeal to be raised, examined by a higher court. Let's see what happens.
Right.
And again, let's continue to pray for the families of Tara Baker, for the families of Edrick Faust, and, let go, let God. What are you going to do? The jury, they spoke. And like you said, it could take forever to get an appeal. But at least in our justice system, there's another level of review. It doesn't stop right here. And that's what's so beautiful about, our justice system, because some cases have been overturned based on judges' decisions. And I think at the very least, he should be able maybe to come back again and get a second try this time, maybe be allowed to use 412, his theory of the case, not to demonize her. But if that was his real defense, I think he should have been allowed to speak on it.
Yeah.
Yeah.
I don't. Have you ever, as a defense attorney, I was never a criminal defense attorney, as you know, as a defense attorney, as a criminal defense attorney, have you ever defended a client that you truly believed did not do the crime and was convicted? And how did that feel?
Fortunately, that's never happened to me, but I have defended defendants who were accused of committing a crime and were indicted, and we're just like pre-trial, and I did my end to do investigation and come up like it wasn't him, it was the wrong person. And I was able to, right before trial, convince the DA that they had the wrong person.
Oh, and the case was dismissed.
Yes, I had that happen. several times. And my colleagues used to say, why are you so scared to go to trial? And I would say, I'm not scared to go to trial. It's just that when you go to trial, anything could happen.
Right.
So if I know my client is not guilty and I go beyond to be investigator, and even when they can't, like I did the most. And it wasn't because I was scared to go to trial. I just didn't want to leave it in the hands of a jury when there's another way to figure it out. Some
Right.
people would just say, girl, just keep billing. No, it's not about billing. It's about protecting your client. And as we can see in this case, no matter how much reasonable doubt is unrefutable, the jurors do what they want sometimes. They nullify the law. They put aside their common sense, even though the judge says, don't go with compassion, go with the evidence and this and that. Here, they went with compassion for the victim.
Right.
Because if they did not, if they really put their reasonable doubt hat on, that shit was there.
Right.
But they wanted justice for her. 21 years, her parents suffering, and the way she was murdered. Somebody had to pay. And that's what was in the hearts of the jurors. And it just clouded their ability to really look at the evidence and follow the reasonable doubt burden of proof. So they just went with that.
I think also some jurors see and hear DNA and they can't hear anything past that. It's like, oh, his DNA was there, he's guilty.
Yeah, but with this, you have his DNA was there, wrapped up in paper, under broken slides, accidentally with empty. Come on.
And none of it was sperm. None of it was seminal DNA, by the way.
Like, I just don't understand that, you know? And not to, you know, make the victim look like a villain at all. We're talking about just reasonable doubt, because I don't want anybody to take sound bites from this.
No.
And clip it, you know, and try to make it seem like you and I are sensationalizing this situation. We're not.
Heartbreaking. It's heartbreaking. But
because, you know,
the system
after
has to work for everyone. It's
I
not
was
justice
on-
for Tara Baker if the wrong person is convicted.
Exactly. I was on Court TV yesterday talking, or the day before, and some people on Facebook came for me. They called me pathetic, an idiot, and said, I'll bet you really also believe OJ didn't do it. You tried to elude that it was a racial situation. Shame on you, Marie Pereira.
Welcome to my life. But what I get on a daily basis is a lot worse than that. I know.
I was like offended and hurt.
It's rough.
They came for me. Came for your girl, okay?
Yeah.
Oh my God.
I know. It happens to me every single day. The trolls are ugly. I mean, this was a racial case. This was a racial case. I don't think that there's any other way to describe this. They did not.
For me, I didn't even go there in my comment, right? I didn't even go there. I'm strictly reasonable doubt girl here. That's all. And the reasonable doubt was not there.
They did not want the jury to hear that a pretty little white girl could have consensual relations with as the defense described him, a bar hopping playboy who also was the same age. They didn't want the jury to hear that. You know, the lead investigator for the cold case unit, Liz, got up on the stand and said, well, when they said, why didn't you, Chris Melton's DNA was all over her. Why wasn't he a suspect? She said, well, his DNA was supposed to be there. As if it's impossible for a boyfriend to brutally rape and sodomize his borderline fiance, because that never happens. So his DNA was supposed to be there.
See, that's what you call confirmation bias.
Right.
And when you start an investigation with a certain theory that he's her boyfriend, so he could never rape her. Right. Once she gave consent in the past, it's perpetual consent, which is ignorance, by the way, because you could even be found or accused of raping your own wife, much less a girlfriend that started to rebuke you and didn't find you worthy to be with her. And there were people who testified that it wasn't such a great and wonderful relationship. So he had means, opportunity, and motive. And that should have been really looked into rather than try to find ways to solidify his alibi that they really never even confirmed.
Yeah.
How you don't say I was at work, but you don't remember where you work. You don't remember the phone number of where you work. They never went to look at cameras. They never went to ask anybody to corroborate what you were saying.
Right. And he didn't remember going to the bank that morning. And then, so he didn't remember that the day of the murder. And then there's all kinds of sketch with the guy who was with him, this guy, Josh. And then Monday morning, he goes back to the bank to apply for a loan.
And then let's
Sorry,
not
your
talk
girlfriend was
about-
just brutally murdered and you're going to apply for a loan at a bank 3 days later. Why? Did he need attorney's fees?
Who knows? And then the injuries he had on his hand. They said they didn't thoroughly examine his hands the first day when he came to identify the body, right?
Right.
And he came 2 days later and he had a lot of bruises on his knuckles and even a cut on the inside of his thumb, right?
Not even
He
bruising.
said-
It was like all cuts. It was all like
right.
cuts.
He says that he punched drywall and maybe he hit some studs or something.
Right.
And that, but they did say they went to the house and they saw the damage to the wall. Because
Yeah.
he said he must have punched the wall like 30 times.
Yeah,
But
he
they
had a story
said-
for that too.
Right.
He had a story for that. He said his parents were with him and hugging
Yeah,
him.
they,
and he
yeah,
felt
they grabbed him
claustrophobic.
and yeah.
But the investigator who took his statement on the day said that he went home alone and he was alone and he punched the wall. Like there's so much
Again,
reason-
reasonable doubt.
so
Reasonable
much
doubt.
reasonable
That's the
doubt.
standard. That's the standard. And so I think a lot of circumstantial facts came out
Mhm.
that didn't support the prosecutor's theory of the case. And they tried to make it seem like it was a direct evidence DNA based case, but it wasn't because the DNA was so weak, old, dusty, unverified, no chain of custody that they needed more to bolster the DNA and they didn't have it. Like if they said to me, okay, the DNA was just horrible, which is undeniable, but there's a video of Mr. Faust coming out of the house, I'd be like, okay, then.
Right. Or they
That's
found
not
his
DNA,
fingerprints in the
but
house or his
presence
DNA.
verified. But all they had was a bunch of random people who helped the sketch artist draw a sketch who couldn't even identify really what he was wearing.
Mhm.
That's all they had. If they had undeniable proof of his presence, apart from the DNA, I'd be talking another story here. But the DNA was so weak, it shouldn't have been allowed to stand alone for this conviction.
Right.
Anyways, thank you so much for having me
Oh,
on.
thank you so much for coming. I think we know what the result here is going to be. It's going to be probably life. I guess LWOP wasn't an option in 2001, but it's probably going to be life plus. She's already made up her mind, and she'll have a justification for it. But thank you so much for coming. Would you please come back again some other time? We can talk
Oh
about.
my God, you have my number, and I want to give a shout to my friend. Her name is Anna, and she's a producer on Island TV Network.
Mhm.
She loves you, and
Oh,
she was
thanks.
watching your show, and she said one day you random mentioned my name and said, if anybody knows how to reach Marie Pereira, tell her to contact me. I'd love to have her on. And she texted me, and she was like, oh my God, do you know who Melanie Little is? And I said, no, I'm not sure. She was like, oh my God, everybody loves her. She called out your name on one of her programs. And she said, anybody, and I was like, oh, and that's when I DM'd you.
Oh, I love that. I love that for
So
us.
shout out to you, what you do. And it's not just entertainment.
No,
It's
we're
the
not
pursuit
here
of
for entertainment.
justice.
I'm not here for clicks and likes. You know, if I was here for clicks and likes, I would be covering Nancy Guthrie's disappearance. Okay, this is not like
Yeah.
a well watched show or topic for me. That's what I would be doing is Nancy Guthrie. So I'm here for justice. I'm here for
An
shouting.
understanding of the law.
Yeah.
Understanding of the law. Let's understand it. Anyways,
Thank you, Marie. We love
with
you.
all,
Everyone in the
and
chat
keep
loves
in
you
touch.
too.
You have my cell. Do what
Me
we
too.
do next time. We'll coordinate and just stay fine and beautiful.
You're the best. I love you. Thank you so much for coming.
All right, bye.
Bye. That was a treat, wasn't it? I mean, I love Marie. I love her. She goes on Court TV, she goes on Long Crime, and she does not hold back. She says what she thinks, and I love that about her. And I'm so glad that she found me so that I could bring her in today. We're waiting. The court's on break. If you're just tuning in, she has decided to allow Ahmaud Cruz to look up the law as it existed in 2001, because those are the sentencing guidelines that the court is bound by, not by the present guidelines, but by the guidelines that existed during at the time of the crime, which was 25 years ago in 2001. So Mr. Cruz is looking up the statement, looking up the law. She's allowing it. And I've been in my head making a playlist for this trial because, and it starts with, you know, the night the lights went out in Georgia.
All right, counsel.
Here we go. We're back.
Yes, sir. Did you want to say something?
Yes, ma'am. I had an opportunity to look at the law. We withdraw the merger. I did look at the law from 2001 in regards to aggravated sodomy and rape. We withdraw the merger from that count. Count 1 was correct. You have the option of life or life without parole. Count 6 is correct. It's still 1 through 20 years. But we would change our request to count 7. The minimum is 10 years, so we would ask for 10 years. And that's in regards to the aggravated sodomy. Count 8, rape, is 10 to 20 or life. We would ask that the Honorable Court exercise its discretion and sentence Mr. Faust to the 10 years, and count 10 as well as the 10 through 30. We would ask the Honorable Court to exercise its discretion and sentence Mr. Faust to the 10 years. Thank you, Your Honor.
Thank you. All right, counsel. I'm actually going to give you both, all 3 of you, 15 minutes to do some homework. And here's why. The state has asked the court to sentence this defendant to the maximums, and the defense has asked the court not to do that. And of course, the 2001 law is not something that is readily accessible and readily available, and it is a little bit different
Shouldn't it
than the
be?
law now. The question I have for both counsel is, pursuant to the rape statute and also to 1710 6.1, what your position is on whether the rape charge carries the possibility of life without the possibility of parole. I'm doing some research based on the state's request and the defense's request as to whether in 2001 that was a possibility. 1710 6.1 is the violent felony, the statute that applies to violent felonies. And I think there is an understanding among cases that happened back then that the count of rape could carry with it the possibility of life without the possibility of parole. I'm going to ask the 3 of you to look at that. I'll give you 15 minutes. I'm going to go finish my research. I'm asking you to do that because both parties have asked for opposite ends of the sentencing structure. State has asked for the maximum, which they are contending is life on that charge, on the rape charge. The defense is asking, of course, for that not to be considered. And so because of that, I'm going to ask you all to look at that. Yes, sir. Anything before I leave the bench? All right, I'll be back in 15 minutes. Thank you.
I mean, look, does it really matter? It's just another issue for appeal, right? He's 48 years old. Life without parole. The best hope for him is a new trial on appeal. That is the best hope for him. Thank you. Ellen loves watching Marie as well on Court TV. Devil went down to Georgia. That's another one. Devil. I mean, we may have to start a playlist. So the first one on my list was, this is what we do here, I think, in song lyrics. The night the lights went out in Georgia. We've got Devil went down to Georgia. I have a redemption song, Bob Marley. She's Already Made Up Her Mind by Lyle Lovett. This is a travesty. I mean, what was the other one I said? She's already made a redemption song. The Devil is in Georgia. The Devil. Bob Dylan, Hurricane. Excellent suggestion. Zimmy. I Want to Break Free. Thank you, Monique. How about Kesha's Praying? He just moved out of Athens, you guys are saying. Yeah, notice how Cruz and Hill just stood up for the judge leaving and the DA stayed put and started talking before she left. Well, we've got a 15-minute break, so we've got about, I don't know, probably 12 minutes left to chat. and talk about your feelings, because so many of you, and I've heard you talking on other channels, in other forums, I've read your comments, and there are so many of you who have admitted to yourselves that you were very naive about racism and that the fact that it still exists in 2026. And this was a live peek at what really still goes on. And so many of you were heartbroken to find that out. I saw some of you on Sylvia's show the other night talking about it and calling in. Sue says, Doolin heard Karen's case regarding her phones. Diller called in, no papers taken under advisement. Huxtall. I looked on the calendar today because I was going to call into that at 2:00, and it was not on the daily calendar for Norfolk Superior. So if you want to email me that information, the papers have been impounded, and so they did not want anybody to watch it. So I don't know if you watched it on Zoom or anything, Suze, but I'll talk about Karen another day. Thanks for your 5. You can always just email me. Mama Shea, thank you so much for your 10. She's saying all the things. I love this. I think that was about Marie from way earlier. Lisa Lott's missing robe is here. Excellent username. Some people want to say racism isn't real, but yet here you have a man going to jail, prison for basically walking while black. We're living through a history rerun. Shaking my head. And isn't it Black History Month also? Yes, we know about the crowdfunding. I've linked the chat. I've linked the Give Send Go in the chat for those of you who care to donate. It's also in the show notes below this video. And when I posted it also on YouTube. I just want to do a quick check and see what it's up to now. Appeals are so expensive and they take so long. There's a man named Colin Miller who has a podcast that I wasn't familiar with until he just agreed to potentially work on this appeal pro bono. He's got a podcast. Like, you guys can remind me what it's called. Maybe Undisclosed. Hold on. The Give Send Go is up to $13,993. When I posted it last night, I think it was around $1,700. So only if you can afford it. Every dollar counts. Undisclosed is the podcast. Thank you. There's no way to know how much an appeal would possibly cost between attorney's fees, printing costs. Really. You make a motion for a new trial. Then if that's denied, then you appeal. That's how I would do it. There are several avenues available. If there is a new trial, there's going to be lots of costs involved with that. How much money did Karen Reed, her Give Send Go, raise in the end? Well over $1 million, right? And that was a trial. Thank God she didn't have to appeal, but she also did have to appeal the double jeopardy issue after trial number 1. So that's not true. Yeah, the fund is for Edrick's appellate costs. Yeah, Heather says the transcript can be over 20 grand alone. Absolutely. Absolutely. Printing is expensive. Any court reporters in the chat? No, you get paid by the page. The transcripts are expensive. The printing costs are expensive. They have to be done by special appellate printers. Thank you, Lisa Lott's missing robe, for your 5. Country Barbie, thanks for being here for 4 months. Says my blood is already boiling. That's from very early on this morning. Crystal Ray, thanks for your 5. Says absolutely heartbroken for Faust and Tara's family, thinking the jury was right. What will they say when he gets acquitted and spewed all this hatred? Prayers for him. Thank you, Crystal. Who's protecting Chris Melton? Charlie wants to know. All the way from down under. And Charlie also says, remember, this is what the DA/state wanted for Karen Reed. Yeah. Oh, yes, they did. Jane Q Public says, I'm so thankful that he has family there to speak and support him so the world can see he's loved and cherished and he was railroaded. Most of them were his cousins, right? He was an only child, so he didn't have any siblings to come in and speak for him. His stepmom had passed away. His bio mom had passed away. His dad has passed away. But he does have children and grandchildren. And it's heartbreaking. Thank you, Jane Q Public. And it's heartbreaking for both families. But I feel like after listening to the families' victim impact statements, that they really do believe that Edrick Faust is the right guy. An innocent man, Billy Joel. Thank you, Jackie Zidell. That's I thought about that one last night. Career criminal that pistol whipped his wife. Where did you see that? Because I've never seen that. And it was said in the was it Yalaman Chili who said that? Who said that in their victim impact statement about him pistol whipping his wife on a cruise, or his person on a cruise? Shanta said, there's the Georgia Innocence Project. We should all contact them. I'm sure that not everybody needs to contact them. I wouldn't suggest that anybody contact anybody. I think the best thing you could do, I don't want you to contact anybody involved in this trial, any of the family members, any of the attorneys. I'm sure that his attorneys are on it. And I'm sure that people have tweeted at them, and I'm sure they know all about it. What types of cases they take, I'm not sure. It's just unfortunate that all the help comes in and all the pro bono stuff comes in after the conviction. That's what is heartbreaking. Susan, in my opinion, the items taken were those that would point toward the guilt of the individual. As Edrick had no history with Tara, it leans towards personal, right? The only stuff taken was her laptop, and there may have been files, but it wasn't clear to me about whether the files were on the laptop or they were separate paper files. Also note, many of the podcast episodes of the podcaster who got close to the family by covering this case around, I don't know when those podcast episodes started coming out, 2021, 2022, Crime City Podcast took down a lot of their episodes that had to do with their opinion at the time. I think his opinion that the family thought, and I don't know because we can't get the podcast episodes and I haven't listened to them, that the family thought that it maybe wasn't Chris Melton, but that it was either the lawyer that she was going to dinner with, that she worked for his firm, or the other law student who was in her study group, all of whom were Caucasian, by the way. Lisa said every time he tried, he shut him down. Thank you. Blessed Mom from Texas says, I love this duo, Melanie and Marie. This is so classy. Praying for all. This case was a big injustice. Thank you, Blessed Mom from Texas. Jaded for Justice says all episodes of Classic C Crime Podcast are available on SoundCloud, including Chris's interview, plus much more. Will you go through them with us later someday, please? I don't know if I'd be able to broadcast them to you without Cameron J., who's the author of those podcasts, coming for me. He's also been speaking out as the family spokesperson. We watched, after the verdict, some interviews where they called him the family spokesperson. And so I'd have to find them, and maybe we could all watch them on our own and then discuss them, or I could listen to them and then discuss them with you. But I have to be careful about what I say, and defamation and pointing fingers at other people. There's been a conviction here, right? There's been a conviction. Yes, Jessie Lynn, Tara's own hair was found in her hand, but all of the hair in the home that was collected was all Caucasian hair. There was no African-American hair found in the house at all. There was no there were no fingerprints of Edrick Faust in the home. There was no DNA of Edrick Faust in the home. The only alleged DNA found of Edrick Faust was on Tara Baker, in her mouth. And if you believe the presumptive testing of the oral swab that was sent to California, could have been vaginal cells. It was mislabeled as an oral swab, but none of it was semen. I mean, I was reaching out to Ed Wallace. He's going to take a look at this for me. And so thank you, JD, for Justice, for your for your $13.99 Canadian. I mean, I do have some good news, and that is that the USA women's hockey won the gold medal over Canada. And that is amazing. And I was watching the game before we had to go live, and so I missed it, but I don't even think I taped it. And what was the final score? Let's see if they tell me here. The article is too long for me to read while I'm on here, but congratulations to the USA women's hockey team on winning the gold. And we are still waiting for the judge and the attorneys to do their research because nobody did their research. Rochelle says if an appeal goes through and he gets a new trial, will it be the same judge? It depends. Depends on how long it takes. It depends on if she's still on the bench. Depends on whether there would be reasons to keep her off the case. For example, if and when, which I think I think that Alec Murdaugh is going to get a new trial. I do. But I do not think that it will go back to the same judge because there were issues of the judge listening to Becky Hill and things like that. So I don't think it will go back to the same judge. 2-1. The score was 2-1. And the USA took gold in women's skating. Wait a second. How come the women's skating has not been on prime time? I don't know. 2-1 in overtime. Oh, man. So the answer is it depends. The Judge Newman is also retired. Thanks, Grace Space. Judge Lott would hear a motion for a new trial, however, is my understanding in Georgia, as the judge who tried the case. Are emergency appeal hearings a thing? It not in cases like this, not in cases of new trial motion denied, and then they go up to the appellate court for a new trial. No, we saw an emergency appeal on Kelsey Fitzsimmons, but in this case, there's already been a conviction. There will have already been a sentencing. They don't get pushed to the front of the line for something as such like this. Takes a long time. Thank you, Elizabeth, for asking me that and for being here for 4 months. Thank you for telling me the trial channel has the Karen Reed hearing. I don't know why the papers are impounded. Thank you for that. Crystal says, we are going to rally for Edrick. Karen Reed 2.0 LFG. LFG. Thanks, Crystal. Mama Fix says, I don't know if I can listen to her commentary when sentencing him. If you got to tap out, you got to tap out, girl. Listen, your mental health is the most important thing, right? Aaron says, thanks for covering this trial. A lot of our other law tubers wanted no part of this trial. I appreciate it as much as everyone else does. I don't know if they wanted no part of it as much as like everyone else is just covering other stuff. I don't know that it was intentional, but thank you for your 5 and for thanking me. And I didn't know what we were getting into when I started covering this because I didn't cover any of the pretrial at all. We came into this as jurors, and then I fell into the rabbit hole of some of the pretrial rulings. And so we did do one show. I think it was a week into the trial on some of the pretrial rulings. Shanta says, can you also put give, send, go link in comments later? The link is not working for me. It may be crashing. So just keep trying. That happens when too many people are trying to access it. So it's not in the comments. It's in the show notes right underneath the video. And it's there already right now. So if you're not getting through, it could be because it's crashing and so many people are trying to access it. Dancing Gold earlier said you guys were involved with the podcast. I think you were talking about the Keeping Her Name Alive. I can't with them right now. My heart breaks for the family. It breaks for the family. Oh, it was the DA that said it about the pistol whipping? I thought it was one of the family members. I don't know. I kind of at one point just zoned out during all of it because I just strains credulity. Emily says, truly, humans are so interesting the way they could sit through this trial and not see that this is not justice. Thanks, Emily. Samantha says, I hope anyone that can donate to this innocent man's appeal fund, please do. They're giving an innocent man life for a crime he never committed. Well, that's likely going to be the sentence here. We'll see how much, she gives him on the plus side. Thank you, Samantha Joe. ARR says, Georgia rain, Trisha Yearwood. No one saw a thing except for the Georgia rain. Gives me chills. Thank you for contributing to the playlist. It was her sister that said it. Said Zoni Cole. I'm sure it's in my notes somewhere. I thought that Edrick's family was really well spoken. And I thought they had a lot of passion and they showed a lot of empathy for the family. But they said, you got the wrong guy. You got the wrong guy. But, now everyone that's heard, the DA rattle off all his priors and all of his charges Still doesn't make him a murderer. And people don't get that. They're like, oh, well, he belongs in jail anyway. So, he should just be in jail. Because, he's a career criminal. Some of the trolls are putting in the chat. He's a career criminal. I mean, if you wanted to pin it on a guy, wouldn't you pick a guy who was a career criminal? Maybe. If you wanted to mix up some DNA and send the wrong swabs in, I don't know. Just spitballing with you. Yeah, it was the sister Meredith who said he would pistol whipped his wife on a cruise. That's what my notes say. And poor Kevin Baker, he was 11 years old when this happened. His chances of a normal life after that are just slim. Thank you for your super chat. ARR. JD for Justice, Mr. Hill's favorite country artist is Garth Brooks. Oh, that's right. Remember during when Ahmad Cruz said, give me a country artist. We'll have to find a Garth Brooks song that applies here. I mean, I'm really surprised that she didn't already have her sentence written, because we all know she knows what she wants to do. I guess she just wants to dot her I's and cross her T's for a change on her ruling. Thanks for your super chat. DK says, I'm a white female in my 50s, born and raised in the Pacific Northwest. I firsthand witnessed blatant racism in a recent trip to Texas. I was floored and offended and couldn't believe racism still exists. Shameful. I will go through the chat later to look at all of your song suggestions. So just because I don't, Thunder Rolls by Garth Brooks, says Michelle. James Dean Baxter said he had no sexual crime history, which is very unusual in a horrible case like this. Preach. Thanks, 35. The other Mary B said, gonna cut you down. Change gonna come. Stepmatic says, literally, if everyone on this thread follows the donation link and makes a small donation, we would be doing more for E than he could ever thank us for. Kim is Ladybug says the Baker family has been duped. Objection, Your Honor, said Liz is just as disgusting as the judge and the DA. I mean, this will be her comeuppance moment, won't it? Won't she get a promotion after this? Likely. Imagine by John Lennon. Thank you. I fought the law and the law won. Thank you, Teresa. Oh, we didn't pull our affirmation for a badass today, right? Did we? Wait, did we or didn't we? Mitchell? Mitchell? Or did I do it right at the very beginning? I don't think I did. Garth Brooks, The River. Oh, okay. All right. Well, we only have 2 cards left, so. Affirmation for a badass. Here it is. Positivity radiates out of me like effing sunshine. I don't know. That's not really, it's the first time it hasn't really been. Wait, we did already? Did I put it down? I don't know. There were only 2 left in the box. It was about women on fire. Yeah. Some women fear the fire. Some women simply become it. No, that was yesterday's. I don't know. My brain is fuzzy today. Positivity radiates out of me like effing sunshine. That's why that wasn't a good one for today. It's got to go back in the box. That was yesterday's about fire, right? I know all the days start to blend together, don't they? Well, that's the one that we're getting for today. Then positivity radiates out of me like effing sunshine. There you go. I think I didn't do it today because Marie was coming up. I didn't want to keep her waiting backstage. That was yesterday with the 2 lovely ladies that came on yesterday. Right. That's right. Don't the days all blend together? We spend a lot of time together. We do spend a lot of time together, and I love every minute of it. I hate to see the injustice of it all, but I do love spending time with all of you. So I got that going for me. Let us see. Oh. Okay. All right. Ahmad Cruz has agreed to come on the show. I guess I can announce that now. And we had talked about possibly doing it on Saturday. So make sure you're subscribed. Make sure you hit all your notifications. And he is happy to come on and answer all of your questions. And he is so thankful for all of you. So thankful for all of you and your support of not only him, but his client as well. And it's not, it's not why I do it. I don't do it for clicks. And you know me, I don't do this for clicks and likes and views. I do it because I'm so angry about it and I need someone to talk to about it. And you guys are the ones that I talk to about it. Because most people don't understand the injustices that we see all the time. It's heartbreaking. Thank you, Keith, so much for your Cash App. He says, just for Edrick Faust. Thank you. Thank you for caring. And we're still waiting for the judge to write out her sentencing. And we all know what it's going to be. It's like no shock. Well, thank you, Shelley, for sending me the missing podcasts. She says, the episodes of the Baker podcast are on SoundCloud. There's a lot of fluff. So if you listen, then you'll do a lot of fast forwarding through the beginning and the end. But there's tons of info on the lawyer and very detailed info on a female arsonist, now deceased. But one, the lawyer was a huge suspect, and there's tons of details on what he did after Tara's murder. Two, there also could be a tie to a lunatic that burnt down a house about a month later with towels on the stove. Wild story, and he explains how she died, which is wild as well. You'll probably be interested in the suspects episode, so I linked them below. You're the greatest. You're the greatest. She says episode 8, 9, 10, 11. Thank you, Shelley. When I say that you guys are out there doing the Lord's work, you are. I don't have a team. It's just me. It's just me and you. You're my team. You are my team. And that's wild and insane. And I guess we should. It's been such a long time since I swiped myself out, right? It's been so long. What was the last time that I swiped myself out? Swiper. Keep swiping. Now the whole camera's off the cocktail. I'll have to fix it, but I got a new trackpad. I got a whole new setup here. But anyway, I don't have a team. You guys are my team. You're my team. And you're doing the Lord's work out there, is all I could say. So SoundCloud. Go to SoundCloud. It's okay because they're not back in anyway. Now she cares about the law. You can't put links in chat. But I'll link them to the description. Just go to SoundCloud and look up Crime City Podcast, and I'm sure you guys can do it. You can do it. I think it's Crime City Podcast. It's called, right? Or wait, maybe she tells me in her email. Season 1, episode 8, Tara Baker, The Suspects. Maybe just search up SoundCloud. So go to on.soundcloud.com, and then maybe you could search up Tara Baker.
Thank you.
File that I was looking up. Was that the file that was missing from Tara Baker's house? She's
All right, we're going to go
smiling.
back on the record. I'll speak to the state first. Anything else the state would like to add with regard to my comments about what is now the
smiling?
statute 1710 6.1?
Yes, Your Honor. And I looked at two cases during the time period the court gave us. The first is Velasquez v. State. It is a 2007 Court of Appeals case out of Georgia. Citation is 283, Georgia Appeals 863. There's no negative treatment for that case noted on Westlaw. And also Henry v. State, which is a Court of Appeals case from October 13th of 2017. And the citation on that is 343 Georgia Appeals 157. In Velasquez, the court states that, let's see, our Supreme Court held in State v. Ingram 266, Georgia 324, that a life sentence without parole was authorized only in cases in which the state first sought the death penalty, and we are bound to follow that precedent. And then in Henry, which is a case in which a life without parole sentence was imposed, but due to a 1710(7)(c) recidivist situation, the court, again discussing Velasquez, states that Henry is correct that under normal sentencing, a trial court may not impose a sentence of life imprisonment without the possibility of parole unless the state sought the death penalty in the case. I did see some of the cases which I think the court is making reference to. In the way that they read in the time period that we had, it seemed to be a situation in which the jury had found or not found, or the court had found or not found, aggravating sentencing circumstances that refer back to the death penalty statute's definition of aggravating circumstances. So, there's always the possibility that I'm wrong, but it is my belief, although if the court were authorized to impose a life without parole sentence, I wholly think it would be appropriate under the circumstances of this case. However, I do believe that I have a responsibility to represent to the court what I believe the law to be, which is that we are limited to a sentence of life on both the murder, but also the rape. Thank you, Judge.
Thank you. All right, Mr. Cruz, anything else that you would like to say? This is a legal issue, but we need to make sure we are certainly following all the requirements of the law, particularly as it relates to what the legislature intended in 2001. Go ahead, sir.
Thank you, Your Honor. I don't think I have a position here because we're not asking for a life sentence when it comes to the rape charge, Your Honor.
Okay. All right. Thank you, sir. The reason that the court wanted to ask counsel to look at the law on that is because both sides are, of course, diametrically opposed, really with regard to count 8, which is the rape count. And the court had a memory of some of the law from 2001 as it related to sentencing. 1710 6.1 was a different statute in 2001, but the idea of 1710 6.1 was the same back then in 2001. And that particular charge, rape, falls under that statute as a serious violent felony. There are orders, particularly one out of the Superior Court of Clarke County, that, which was not overturned, supports the notion that under the recidivism notice and statute, that a maximum sentence for a rape charge back in 2001 supports the possibility of life without the possibility of parole. The question then becomes, if that is correct, is whether the recidivism relates back to anything prior to 2001, or does it relate to something after 2001? And so that certainly can be up for debate, and we're not going to debate that now based on the state's not seeking that maximum sentence. The maximum that they are seeking in count 8 is life. And so we will leave it at that. But that is the reason I wanted to ask both of you to look at the law and see really what was applicable in 2001, because both parties, of course, are diametrically opposed in terms of the maximum and minimum amount the court can allow. All right. With that being said, Mr. Yelman-Chile, anything else from you?
Nothing further from the state,
Okay.
Your Honor.
Thank you. Mr. Cruz, anything else, sir?
No, ma'am. We'll just note for our record the recidivist notice objection that we made prior.
I understand, Mr. Cruz, and I want to respond to that very quickly. looking online to make sure that my notes comport with what I saw online. The notice that the state referred to in their discovery, which was filed with the court, was from April the 2nd of 2025. It was entitled the State's Notice and Recidivism Notice in Discovery. That was from April 2nd of 2025. The notice that the state is relying on now, that the defense has responded to, of course, the 3 felonies that they have enumerated in their notice, is from October 2nd of 2025. And so anything further, Mr. Cruz, you'd like to say about that? All right.
No, ma'am.
All right. Thank you. All right. Very good. All right.
Record clear. So from October 2nd, 2025, it's aggravated assault, BGCSA, 2 counts of violation of Georgia Controlled Substance Act offenses. Looking at the recidivism statute, I'm just saying these are the offenses that we have notice of. The state has asked the court to take to consider other offenses that there was no notice given. The state's argument when we brought this up initially was that, hey, in discovery, we just filed a general notice and whatever could be used as for purposes of recidivism. Our argument, it does not. It has to be specific. So we are on notice of these 3 specifics.
Thank you. All right. So I just want to respond to that very briefly. The law allows the state to provide notice in the manner in which it did. From April the 2nd of 2025, their general notice in their discovery that they filed with the court, and of course, the actual notice that they provided the defense on October the 2nd. I will say, however, that the court is going to take into account in sentencing Mr. Faust the notice that was filed October 2nd that the defense has no objection to, and that is the one that I will certainly take into account in sentencing. With regard to this case and sentencing and taking into account the notice that was filed on October 2nd of 2025, the state's argument about sentencing and the defense's argument about sentencing, the court finds as follows. Mr. Faust, please stand.
Here it comes.
This court finds, based upon the evidence presented at trial and the jury's verdict, that a sentence involving rehabilitation is not appropriate in this case. And I'm going to sentence you, Mr. Faust, as follows. With regard to count 1, life. Counts 2 through 5 are what we call in the legal world vacated. That means no sentence, and that is imposed as a matter of law. Those are the felony murder counts. With regard to count 6, which is the burglary charge, 20 years consecutive to counts 8 and 10, which I will get to in a moment. With regard to count 7, which is the first aggravated sodomy charge, 30 years, and 20 years is 20 years confinement. Count 7 is 30 years in confinement. That is concurrent with count 1. Count 8, the rape charge, is life. That is consecutive to count 1, which is the other life sentence. With regard to count 9, the court agrees that count 9 does merge with count 1 as a matter of law, and that's the aggravated assault charge. With regard to count 10, which is the other aggravated sodomy charge, the court imposes 30 years in confinement. That is consecutive to count 1 and 7. That is also concurrent with count 8. Count 11, which is the arson and the first degree charge, the court imposes 20 years of confinement consecutive to count 6. And count 12, which is possession of a knife during the commission of a felony, the court imposes 5 years in confinement. That is consecutive to count 11. The order of the court are 2 consecutive life sentences to be imposed, plus an additional 45 years to be served in confinement. That'll be the order of the court. You are in custody. Thank you. Court is adjourned. And everyone, please remain seated until the Sheriff's Department determines who can leave and when they can leave. Thank you very much for your cooperation.
Let's just watch. For a moment. And Mr. Cruz is hugging Mr. Faust. And the judge has handed down her sentence of 2 consecutive life sentences plus 45 years. Consecutive is one after the other, as opposed to concurrent, which would mean at the same time. 2 consecutive life sentences plus 45 years, which, based on his age of 48, means that he will never, ever, ever see the outside of a prison cell unless and until an appeal is successful. I was typing that up, so I just want to rewind and watch again.
I just want to respond to that. The court agrees that count 9 does merge with count 1 as a matter.
The defendant's reaction as the final sentencing was read. Or actually, while she's reading it, life plus 45 years.
To Mr. Faust as follows. And the jury's verdict that a sentence involving rehabilitation is not appropriate in this case. And I'm going to sentence you, Mr. Faust, as follows. With regard to count 1, life. Counts 2 through 5 are what we call in the legal world.
Look at the bailiff. I'm not sure what she could be, a court officer. I'm not sure, who is standing beside him with her back against the wall. I think she's a court employee. Look at her face.
World vacated, that means no sentence, and that is imposed as a matter of law. Those are the felony murder counts. With regard to count 6, which is the burglary charge, 20 years consecutive to counts 8 and 10, which I will get to in a moment. With regard to count 7, which is the first aggravated sodomy charge, 30 years, and 20 years is 20 years confinement. Count 7 is 30 years in confinement. That is concurrent with count 1. Count 8, the rape charge, is life. That is consecutive to count 1, which is the other life sentence. With regard to count 9, the court agrees that count 9 does merge with count 1 as a matter of law, and that's the aggravated assault charge. With regard to count 10, which is the other aggravated sodomy charge, the court imposes 30 years in confinement. That is consecutive to count 1 and 7. That is also concurrent with count 8. Count 11, which is the arson and the first degree charge, the court imposes 20 years of confinement consecutive to count 6. And count 12, which is possession of a knife during the commission of a felony, the court imposes 5 years in confinement. That is consecutive to count 11. The order of the court are 2 consecutive life sentences to be imposed, plus an additional 45 years to be served in confinement. That'll be the order of the court. You are in custody. Thank you. Court is adjourned. And everyone, please remain seated until the Sheriff's Department determines who can leave and when they can leave. Thank you very much for your cooperation.
She is wearing a Sheriff's Department uniform. And Mr. Cruz, I couldn't really see him because he was sort of blocked by, I mean, Mr. Faust, he was sort of blocked by Mr. Cruz. There was just sort of like shaking his head like he knew this was going to happen. And then he shook hands. And he's probably saying something to him like, I'm not giving up on you. And there's another sheriff's uniform standing there. He doesn't look happy either. I don't know. I was told by our boots that there's a hug between attorney and client. And they're walking him out now. The Sheriff's Department is walking him out. And I've been told by boots on the ground that court personnel did not feel like this was a fair proceeding, did not feel like this was justice, did not feel like they had the right guy. Sarah Brown says, trust me, the people of Athens and surrounding areas are not happy with this. Innocent man walking, says Jazz RN. Priscilla said that hug was powerful. Donna, unbelievable. Brooke, I can imagine. Roach Hard Abs says this could be any of us. They certainly did not have the right judge, says Anne. I guess Jess says, my heart is just shattered. This is so effed up. I wonder if there's going to be any cameras outside the courtroom. I wonder if the DA is going to give a little presser. And what do you think he's going to say? I hope that Liz doesn't tear her rotator cuff patting herself on the back here. Country Barbie says the Green Mile always came to my mind during this trial. Brianna Lynn says they're plotting how to get the F out of Athens Clarke County. Chris says, I'm just shaking my head. Tara Howard says, we are angry as hell here in Athens. Sick. Tiff says, justice wasn't served. I live for now says, it's just heartbroken. No words. The world is watching. Meeman says, sorry, but the jury got it right. Genuinely, I'd like to know what evidence that you're relying on to say that he actually murdered her. That he actually murdered her. I mean, if you've got any evidence that makes you feel that the jury got it right, please point it out. Put it in the chat, MeMan60. Because, you know, opinions that the guy was a career criminal and so therefore he did it, that's not enough. There's no evidence that he was in the house. I didn't hear any evidence that he was in the house. I heard plenty of reasonable doubt. And that's what our system is based on. The standard is beyond a reasonable doubt, not he probably did it. Maybe he did it. Because if you think maybe Chris Melton did it, that's reasonable doubt. Liz was all smiles during victim impact statement, said Mama Fig. Two consecutive life sentences plus 45 years. If you can, and if you feel like you want to, the defense fund for the appeal and the motion for a new trial and everything to follow, the link for that is pinned in the chat. Allison Jones said, even the DA said, can't prove burglary, but they said guilty. Make it make sense, please, someone. I can't. Bleacher says circumstantial evidence. And juries convict on circumstantial evidence all the time. But is, you know, there are two people coming in and saying there was a black man walking with an orange shirt on at 8 a.m. and he looked suspicious because he looked wide awake, but he wasn't carrying anything and he wasn't running. And nobody even ever pointed and said it was him. I mean, is that what we're going to convict people on and then sentence them to 2 consecutive life sentences plus 45 years? There was never a black suspect ever in the mix for 25 years. You should all be very afraid if you live in Georgia. DNA can transfer lots of ways. Touch DNA. There was no sperm found. Chris Melton's pubic hair was the one found by her anus. She was brutally sodomized in the anus. Strange Credulity said, this is absolutely egregious. This is why we must continue to watch the people in power and the injustice infiltrating the American judicial system. Shanta says, they always say every dollar helps, so give, send, go. Thank you for your super chat. Hey, it's me, says I need to watch his closing again before Saturday. Thank you, Glamasus, for gifting 5 memberships. You're so very kind and generous. And Strange Credulity, thank you for gifting 5 memberships. Ashley Nicole became a member. Welcome. Charlie said even the sheriff knows he was railroaded. Melissa says possible parole or no, because 2 life sentences. And they're consecutive. They're not concurrent. So yeah. Doesn't seem like that. Yeah, Love from Tejas says, it seems like, if I can find your comment, is this even worth appealing? 100%. It's always worth appealing. Should he just give up? Should he just give up and sit in prison for the rest of his natural life for a crime that he swears he didn't commit? Creating Through Chaos says your DNA is everywhere. You don't even know it. You better hope it's not in the wrong spot and you end up in a position such as this 25 years later, trying to defend yourself about and have an alibi for where you were 25 years ago today. True crime justice says we ain't got no quit. True Crime Junkie says, I live in Georgia and hearing an investigator saying my boyfriend's DNA should be there makes my skin crawl. Justice for Edrick. A lot of you are very sad. I know. I feel your pain. But there's a lot of people out there who are on the complete opposite side of this. The trolls who think John O'Keefe was hit by a car, for starters. And I think that's where they're all coming from. So, try and block out the noise. She wants to throw the whole law library at him. Shanta says it's $225K asking, 14K sent so far. Well, that's in 24 hours. The thing was only put up 24 hours ago. Hopefully the pro se happens. I think you mean pro bono. Pro se is a defendant representing himself. Pro bono means free. Karen Reed had international attention, so got a lot of money. This case isn't out like Karen Reed. Yeah, well, we're just starting. Thank you for your 5. We're just starting. Thank you, Jadzia, for your super chat. She says she wants to throw the whole law library at him. We need to make this case bigger, says Avala. Tell your friends, tell people about it. It was a very busy news cycle for the past couple of weeks while this trial's been going on. Nancy Guthrie disappeared. It's getting tons of coverage. It's there wasn't a lot of room for this case, I guess. But hopefully people will start to pay attention now. That'll be great. Says, remember all the DNA tested in Karen Reed, all just to confirm John O'Keefe was John O'Keefe? They didn't even look for anyone else. Nope. We have a nope emoji for that. Could the judge have dismissed for lack of evidence? Yeah, the defense made that motion after the close of the state's case. Denied. Miss 25411 says, I wish I watched the whole case. I still don't understand why his DNA was there. Go back and watch it. Watch my playlist. It's linked below this video. You can watch the whole entire case. Except for portions of day 3. I was very sick that day. I don't think there's anything to do to make an appeal happen faster. I just don't. Right. Plus his mom from Texas says Nancy case has thousands of people just watching while someone is getting railroaded in front of our face. Yeah, listen, I'm not saying that case isn't important. Right. But did they mislabel the swabs? That's a great point. Why were there 2 oral swabs and a vaginal smear, but no vaginal swab? Thoughts, questions, comments, concerns before we wrap. Charlie said, remember the DA and state tried to convince a jury that a 2-ton SUV doing 20 miles an hour could hit and kill John O'Keefe without leaving so much as a bruise, right? Right. Angela says, Cruz was incredible throughout this case. Because of him, we were able to see all the reasonable doubt. Imagine if he was allowed to resent everything. There's a typo in there, but I think I'm picking up what you're laying down. BB says you can have someone else's DNA in your mouth from being in the same store, restaurant, having a conversation, etc. Tara Rayner says Chris whispering to himself to hold it together was telling. I doubt if he did murder Tara that he has been violent since. Yeah, I gotta go watch the women's hockey game. That's what I'm gonna do. That's what I'm gonna do. And how was his hair there if she just took a shower? All great points. What you're going to want to do is you're going to want to make sure you hit the subscribe button. You're going to want to make sure you hit the notification button. You're going to want to make sure you enable all notifications on your phone. And so that when I put up the stream that Ahmad Cruz is going to be coming on the show because he's agreed to, you will know exactly when that's going to be. I also post on Instagram. You can find many of my things there. And so think about the questions you would like for me to ask Mr. Cruz. We were tentatively talking about Saturday, but we'll see. And I can't wait to hear what he has to say. I think he's going to be a big star. And, you know, he's passionate about justice. You can just see that. And I think he did the best that he possibly could with the case that he had and with the restrictions that he was under from this judge and these pretrial rulings. And hopefully we can make a difference here. Music to my soul. Do I have a P.O. box? No, I don't. Thank you, though. Thank you. I am covering the case. If I find out an address where you guys can write to Mr. Faust, I will put it in the show notes. Zeke says the people of Georgia need to ask any future DA and governor candidate one simple question. What are you going to do to get Mr. Faust out of prison? Also, how do we ensure F-tards don't end up on juries? Thank you so much. I try to avoid the F word in the chat because YouTube doesn't like it. So please like the stream, hit the bell. Blessed Mom from Texas says, this channel deserves over 200K subs, a real honest channel. Thank you. Thank you to the moderators for trying to keep it classy. I know it's difficult with a case like this because the trolls are coming out of the woodworks. She took a shower. Her roommate testified she took a shower every single morning, and then she blew dry her very long, very thick hair and had 2 bags of cheesy grits. And her hair was wet because one of the firefighters could smell shampoo. So, of course, she took a shower. All right, you guys, this is a lot to process for all of us. I know it is. Stay cool, stay kind, stay classy, stay safe because it's a jungle out there. And I'm going to see you real soon. I love you with all of my heart. Thank you for caring and for being the wonderful group of Snark Tank cupcakes that you are. Peace. Just another day of injustice. Peace.